Lordship praying for listing one IA criminal. Lordship, if possible, any convenient short date.
6th of March.
Please, Your Lordship. Your Lordship, we filed an anticipatory bail today. If Your Lordships may kindly allow us to allow it to be heard today, if it's possible. Anytime.
We have some part-heard matter, no?
May I request for tomorrow, Your Lordship? In that case?
Tomorrow is not.
There's a little personal difficulty on the part of the
No, whatever. We don't have any time. Second will do, 2nd of March.
In that case,
Next
Your
Monday.
Lordship, can the arguing counsel appear online for the matter if it's permissible?
Pardon?
Can the arguing counsel who is appear
we'll
online?
See to it. No, now at this stage we cannot allow, but we'll see to it. It will be listed on 2nd of March.
May I please, Lordship? Lordship, I beg to mention item number 18, Lordship. Lordship, can it be listed on 18, Lordship? Lordship, can it be listed on 27th of February?
What is the position of 18?
Scan copy of it.
TC already received. For BC matter, I could declare morning first. He is seeking for 27. Good, I will. May not be possible on 27. It will be at best on 2nd of March. Otherwise,
Bless me.
I will request
Your Lordship, I beg to mention for listing of criminal appeal, Lordship. Listing for criminal appeal. Any date of next week?
criminal appeal.
Criminal.
6th of March.
Wait, please, Your Lordship. Lordship, this is a regular bail application. Lordship, page 16 is the affair. This is a matter Lordship will probably remember, Lordship. The police personnel came in a Lordship without a uniform and picked up a person, Lordship, Bahurul Islam, Lordship. That person, Lordship, raised hue and cry. In the meantime, there was a cricket match is going on, Lordship. The villager went there, Lordship. In the meantime, Lordship, they are altercated with this police personnel. In the meantime, that Baharul Islam, Lordship, escaped from that place, Lordship. Now, police is specializing these villagers to, Lordship, produce that Baharul, Lordship. This on this ground, Lordship, this petitioner was arrested on 6/2/2026, Lordship. Other person, Lordship, who are named in the affair, they are approached before this honorable court, and this honorable court has granted interim protection, Lordship. That order, Lordship, will find on page 29, Lordship. Thereafter, what happened, Lordship? Thereafter, what happened, Lordship? In this case, all the case has been fixed on, Lordship, 5/3/2026, Lordship, for case jury, Lordship. Since, Lordship, other FIR named person are granted, Lordship, interim bail, may I pray for interim protection to this petitioner also, Lordship?
No, sorry, 5/3. We are listing it on 5. CDP for.
God bless.
Is to be 35.
But resolved. A regular bail application. Petitioners were in custody since 27/10/25, 30/10/25, and 2/1/26.
3
They-
petitioners are
They
here.
are all brothers. FIL also find page 14, my lord.
Possibly this was rejected earlier.
My lord. By the trial court, my lord. By the court,
By this court?
by the session court. Your order, you will find page
Name is
37 is the order, my lord. There is also cross FI, my lord. In cross FI, my lord, the learned court bill has granted bail, my lord.
Your FIR is at page?
Page 14. This is the FI against us,
This
my
is
lord.
registered under 109 also.
Yes, my lord.
Both cases charge sheet submitted.
Both cases are
Charge sheets are-
my lord.
Okay.
FIR lodged by the father of the petitioner, my lord, prior in point of time, my lord. In that case, my lord, no action was taken by the police. In the FIR lodged by the other parties, my lord, the petitioners were for the same cause of action. The learned trial court, my lord, the session court, has, my lord, rejected the bail only on the ground that the victims are to be examined. While the case in the filed by the father of the petitioner, the bail were granted, my lord. Page 30, page 41, my lord. I'll tell you. And it is the assailant of the, my lord, the accused person laws against the FIR by the father of the petitioner. They have attacked the petitioners, my lord, while cutting a branch of tree, my lord, in the paddy field
Now both the cases are pending before which court?
before the session court, my lord.
Both the cases.
Yes.
So
Lordship
this
kindly
this
consider
order
the,
was passed by CGM
my lord,
while granting
while
bail.
committing the, my lord, before committing. Considering
No,
that
no, before
aspect,
committing, in a sense that that was not the nature of committal in nature.
my lord.
It was not sessions tribal, but because of same cause of action, so both the cases are
Yes,
being
yes,
tried. So CGM granted bail with this your bail petition, where you have moved your bail petition
my lord.
earlier.
Page 37, my lord.
37.
Yes. Relevant portion of the order, my lord, page 39, paragraph 6. My lord.
This is before session judge.
This is before session. The present petitioners before Lordship, they got a severe injuries in their head and hands, etc. My lord. But despite that, my lord, they have not given
Your
bail.
case is not registered under 118 or 109.
My lord, this is the, my police, my lord. Police is not taking action against.
But we
That's
cannot
why,
say
my
at this stage what is there.
that is why, my lord. Other parties are very influenced person, my lord. They have managed the police, my lord. Although the FIR against them, my lord, was filed prior in point of time.
Yes,
Kindly consider, my
Already, yes, charge sheet submitted, my lord. Already in one case they obtained, but in this case, while going through the, my lord, rejection order, last portion, page 37, last portion, my lord.
Hmm.
Regarding the present accused person, Simanto Das, Pavan Das, and Montu Das, my lord. Page 38, mainly, my lord,
38,
fourth
39.
line, my lord.
Hmm.
One eyewitnesses, he further deposed that Simanto Das attacked him by the posa, and when his son Vikas Das tried to obstruct the blow of the posa by means of his hand, the posa plunged into his hand and came out from the other side of the hand.
good, Bab.
And because of then
Allegation is there, my lord.
because of that, my lord,
Same
probably-
allegation, your lordship will go through the, my lord, FIR lost by us, my lord, father of the petitioner.
No. This is the statement.
My lord.
PW1 means
and when my lord
This
last
sort of statement will also come in the case, in our case, my lord. If we
Whatever.
allow to, my lord, give statement.
and one handicap that are, my lord, last portion, my lord,
Sabitri Das.
below, my lord.
Savitri done.
Pavan Das, they have to hit on his head, Sabitri Das by Sandal. So because of that.
If the courts allow, my lord, this kind of allegation will also come in our evidence, my lord, since they have attacked us. They consider a length of detention, my lord, October, from the month of October, my lord. And all the brothers, my lord, there. And most importantly, the other persons are very influential persons. They manage the police.
Yes, what?
Kindly consider that.
My lord, otherwise, yes, from the materials, because why rejected, my lord, because of that handicap, my lord, one Sabitri Das was attacked, and regarding Osa by that Montu Das. Well, otherwise, considering that, my lord,
Any
yes,
strict-
charge sheet submitted in both the cases.
I think it's strict condition
Otherwise,
review.
materials is there in that in the present case, my lord, against the present accused, three accused persons.
Your case number is now pending.
24 mile, my case. Or search file, it was not, it was already committed, mile. Evidence is yet to be started, mile, only because the petitioners are inside the jail. Mile.
This has been registered as the sessions case number
My
3.
case is, yes, their case is, my lord, registered as session case. While our case is yet to be, it has been registered, but I could not get the information since the petitioners are inside the jail. All the family members. The record says, my lord, this has been.
Department Second 11 should be report petition be appearing on the opposite. Application section students. It is submitted by Mr. Secretary Planet of the petition that all the petitioners are parties. And the mother of the petitioners were in the earlier point of time had lodged an FIR against the informant and some others. But instead of registering the case of the petition, the was not registered in the registered earlier, and the subsequently also been registered. And it is said case, some of the petitioner side also sustained previous injury on their person. But it was charge sheeted under section 191.3, 1172, 3293 BNS, and the learned CGM Manjuli also granted bail to the accused persons in the said case. And it's order dated 16/01/6. However, both the cases are now for the learned session just as arising out of same cause of action. Mr. Sekia further submitted that this accused petitioner number 1 is in jail since 27/10/2025. None petitioner in none the accused petitioner number 1, 2, and 3 are behind the bar since 27/10/2025, 30/10/2020, and 22/1/2026. Case is already been considered. Some of the witness with evidence is recorded.
My lord.
Some of the evidence of the PWs are already been recorded by the learned sessions. However, the bail application for the petitioners were rejected by learned session judge by its order dated 5/2/2026, only with the consideration that one of the vital witness is yet to be examined by the prosecution. And the accused petitioners are behind the 6 month. Considering the length of detention, they may be released on bail. At the same time, they will also face the trial, appearing before the learned session judge each and every day to be fixed. Mr. Bott, the learned additional PP subcontinent that the nature of the offense is very serious. The nature of offense is very serious, and considering this nature of offense as well as also consider the fact that the one of the vital witness who is also a handicapped guard is yet to be examined by the prosecution, who is also a victim and a vital witness of the prosecution. Accordingly, Mr. Waterford submitted that considering the nature of offense and the stage wherein the probability of tampering or tampering with the remaining witnesses cannot be denied, and accordingly it is considering this submission by Planet also all other aspects of the case, and also considering the elected detention already under petitions. This court is of that further custodial detention may not be required for the interest of the trial. For the trial, just that in view of this, all the petitioners hereby allowed to go on bed. So with the satisfaction, the session judge
Mazuli. Deeply obliged.
In case of any intimidating, threatening the
Bail-
victim,
Bail
is
can be
very-
rejected.
this will
That can be imposed.
because victim not yet.
How like?
May it please your lordship. My lord, the instant revision, my lord, against Imperial Order 26/12/2025 passed by the Special Judge CBI, my lord. Here in this matter, my lord, regarding despite the registered owner of the concerned vehicle, my lord, the learned Special Judge has granted the custody of the jimma of my vehicle to the private respondent number 3. Lordship, kindly have a look to page 47, Annexure 9.
We need to file.
My lord, this is the application preferred by respondent number private response 3, my lord, for jimma of my vehicle, my lord. Wherein lordship will find the respondent number 1 is the CBI, my lord, and respondent number 3, the present petitioner, Hajira Begum Loska, myself, my lord. And to another Asabuddin Borbe, his vehicle, she also claiming jimma, my lord. In this vehicle, in the light of this vehicle, my lord, application for jimma, application by preferred by respondent number 7, page 51, Annexure 10. This is the reply on behalf of the CBI, my lord. CBI has filed objection, reply in the jimma application of the private respondent number 3 here, my lord. Only specific paragraph I will take your lordship at page 53, paragraph number 8. What is the contention of the CBI in that jimma application preferred by the private respondent number 3? Page 53, paragraph 8. Yes. That in this regard, it is again submitted that the registered owners of the Toyota Innova Krista vehicle bearing registration number 7228, I am concerned this one, my lord. And the Mahindra Scorpio vehicle bearing registration this is respondent number 2, my lord, where found that Srimati Hajira Begum lost present petitioner and Asabuddin Borbe respectively as per the information received from the RTO office at Kasar and Kamrup M. Accordingly, in compliance of the orders of this honorable court, the said vehicles have already been handed over to the said registered owner. Therefore, the instant application may be dismissed. So CBI stand on that jimma application preferred by the private respondent, that it is to be dismissed. Already the registered owners, that vehicle has already been given jimma, my lord. That, my lord, page 54, next page 11, my lord. This is my reply objection, my lord. So far as my claim is to concern that I am being the registered owner. So my case is to be the vehicle already been granted by the same CBI court earlier occasion, same may be custody with me. Then, my lord, imperial order at page 64, that is on 26/12/2025. Yes, my lord. Here, lordship, I'd like to take your lordship, page 67. Instead of reading the whole, only relevant portion I'll read, my lord. Page 67. Lordship will find what is the stand of the CBI in that application are recorded by the trial court. The CBI in the reply in the petition, the petitioner stated that instant affair that so-and-so has been registered at CBI so-and-so Shillong so-and-so under section so-and-so of the banning of unregulated deposit scheme against the Hemant Kumar Gogoi and others. CBI in the reply stated that as per the direction of this court, by order to the 2125 and so-and-so in the jimma petition number so-and-so, they handed over both the vehicles bearing registration number so-and-so, so-and-so, so-and-so to the registered owners of the vehicles. CBI further stated in the reply that a registered owner of the Innova Krista bearing registration number so-and-so, the present petitioner, Milot, so-and-so, found to be Srimati Hajira Begum Loskode. And it is admitted and by the CBI that I am the registered owner and so-and-so, so-and-so, so-and-so. And as put, the vehicles are still in possession of the registered owner, hence CBI prays to reject the petition filed by the petitioner. Petitioner means the present respondent 3 here, my lord. Now, your lordship, page 71, my contention before the learned recorded, page 71 and 72, my lord. Very small paragraph I'll read. Opposite party number 3, the present petitioner, namely Hajira Begum, owner of the vehicle, Innova Krista bearing registration number so-and-so, in her written objection submitted that she is the registered owner of the vehicle mentioned above. The same was purchased by taking a loan from the bank by executing hire purchase agreement. Until that, she has been paying the monthly EMI of the aforesaid vehicle. The opposite party number 3 further submitted that present petitioner with a conspiracy with her husband under the seal of the void ab initio, the said transaction by cheating the opposite party number 3 trying to take jimma of her vehicle for wrongful gain of the petitioner. She further submitted in her written reply that husband of the petitioner, being the close friend of her husband, had earlier allowed the accused husband of the petitioner to use the vehicle on good faith for their personal use. But on so police personnel arrested husband of the petitioner, namely Azad Hussein Majumdar, is the husband of the private aspirant number 3, arrested, my lord. Now, very next place, my lord. The opposite party number 3 further submitted in a written objection that she, being the registered owner, filed a one jimma petition before this court, and the learned court, after hearing the parties and after going through the document, had allowed her to take jimma of the said vehicle, the registered owner of the vehicle. She further submitted in her petition that all the petitioner allegedly tried to show the execution of sale agreement. I objected this, my lord. I raised the question of this fact, my lord. All the petitioner allegedly tried to show the execution of sale agreement between the parties and receiving a cash of amount of rupees 20, but both the aforesaid documents were manufactured with documents as opposite party number 3 neither executed any sale agreement with the husband of the petitioner as well as received any consideration amount. I raised the disputed question of law as well as fact, my lord. But the line court below the findings at page 89. Second paragraph, my lord. The primary requirement of the person to claim of jimma under section so is to demonstrate that they are the person lawfully entitled to possession of the property pending the conclusion of the trial. Once registered owner sold his vehicle and after receiving the consideration amount, hand over the physical possession of the vehicle to the petitioner, the original owner has no longer have a legitimate possessory interest or claim to the vehicle. So in that sequence, the actual purchaser, the present petitioner, is the person who has the rightful claim to the interim custody of the vehicle, even if, my lord, this is very important, even if the registration is still in the seller's name, my lord. And as I discussed earlier, the petitioner, being the purchaser of both the vehicle, filed by the documents, sale agreement executed between the parties, money received for full consideration amount of the vehicle, the vehicle transfer documents and so. It is also found that the police seized both the vehicles from the possession of the petitioner in connection with Hailakandi PS case number so and so. We detailed the proof that petitioner till date the seizure of the both the vehicle were in physical possession of the both the vehicle. From the above discussion, it is crystal clear that petitioner being the purchase of the both of the vehicle and was in physical possession till date the seizure is the lawful owner and he has the right to take interim jimma of the both the vehicle till disposal of the instant case in certain terms of the condition. My humble subject, my lord, in this matter, how the learned trial court, the severe court can help them decide the question of ownership here, my lord. She has placed only one document, the sale agreement, where I disputed this on question. Even the council, the CBI has represented, file objection. The present petitioner is the only the owner of the registered vehicle. The registered owner till date, my lord, but learned trial court, without taking any evidence, any witnesses, my lord, simply one document relying, my lord, declared the ownership to the private respondent number 3, my lord. And my lord, and the rest, my lord, these are the grounds given for jimma. According in the life of this order, my lord, at page 93, annex 13, on 2/26, finally, my lord, handed over the vehicle to the petition number 3. My lord, this all the things that has been done by private respondent but suppressing fact. What she has been done, this has come to a letter to our knowledge. See, my lord, once she's after obtaining the jimma, in the meantime, before obtaining the jimma application, my lord, she preferred money suit against our page 95 with the page 14. She preferred a money suit, my lord, claiming that there is only one paragraph from the money suit, my lord, page 95, annex 14. I will read, my lord, paragraph number 5. She's trying to get real benefits, my lord. Page 96. Paragraph, yes, 4 and 5. The husband of the plaintiff was arrested in connection with the special case number so and so pending before the special the CBI Assam Additional Court number 2. And taking advantage of that, defendant submitted a petition before the court of special judge so and jimma of the sued vehicle. And the special judge allowed the jimma of the vehicle in favor of the defendant. And accordingly, defendant number 1 has taken the custody of the vehicle on so and with all the documents. He and accordingly released order so and. Paragraph 5, most important, my lord. The defendant, by taking custody of the vehicle, has breached the agreement of sale, and as such, she is liable to return the consideration money of the vehicle with compensation of cost. Accordingly, paragraph 6, she is claiming 14 lakhs in return. Therefore, my lord, one part This fact, this case she has filed, my lord, lordship will find at page 98 on 13 June 2025. But this fact never been brought before the knowledge of the CBI court as well as before she approached before the High Court. This fact she has never brought a record, my lord. That 13/6/2005, the CS preferred a money suit for claiming of that this amount, my lord. Without bringing knowledge, my lord, she obtained all this order. And so my submission in this matter, my lord, the present respondent number 3 obtained this the jimma of the vehicle, my lord, by the one side she has obtained the jimma of my vehicle, another she preferred in managed in this case, and in a learned trial court below, my lord, though CBI has represented as respondent number 1 and me as represented respondent number 3, we both objected, and I'm claiming that that document by showing she is claiming the ownership of the manufactured and fraud, my lord, false. And CBI has also admitted, yes, I am the registered owner of the concerned vehicle. So without taking any evidence on witnesses,
Yes,
discuss.
May I please, your lordship? This is the stage of motion. And so far I remember and recollect, one petition has already been disposed of by this honorable court in respect of subnum. So I need to give appropriate reply, and I will have to deal with that petition which is already released in favor of subnum. And in that petition,
This is by the
learned High Court, from
High Court.
High Court. And they were made party. They have not, if at all there is any civil order, civil court's order, they have not brought before the court. So let me verify everything in sequence. What is the position? Then only it can be heard.
In your information,
Subnam has already been, her petition has already been disposed of by this honorable court. Yes.
Well,
So,
page
I
30
need
and
to
Excel
deal
7.
with.
and in that case, they are also party.
They are also made party.
Okay.
So now the question is whether this will be maintainable at this stage when one matter is already disposed of by the High Court itself.
No,
So
ma'am.
I need to deal with everything. And as of now, I have only this petition and the few orders annexed by my learned friend. So I need some time. It is pertain to Shillong branch, registered by Shillong branch. Please 2 weeks or 3 weeks time may kindly be given, because I will have to go through all that petition also, order of the Honorable High Court, then order of the Civil Court. That petition, I need to say what were their relief they have asked for in the Civil Court. Because this is a simple order here, but under what was the prayer in the Civil Court's order, that I need to see. So it will take some time. At least 3 weeks time may kindly be given.
Lordship, on my learned seniors friends from the query, my lord, the answer is very much here, my lord. Annexure 7, page 30 is the High Court's honorable court's order.
Yes, one
Yes.
order is there.
Yes, yes, yes. My lord, page 32, Annexure 6.
I'm not hiding anything.
No,
but
no,
please,
no, no,
I
no, no,
need
no,
to
no,
see.
no, no. I must appreciate you.
32.
Yes, Miss 32. But so this is the application.
This is passed by whom?
My
Additional
lord,
CBI.
these were dismissed by the CBI. Against this order, she preferred a revision before this honorable court. I will take the page 32, Annexure 6.
No, 32 is okay. Where
Yes,
is this
my lord.
this court
Yes,
order?
this order rejected the earlier jimma petition preferred by the respondent number 3. Then she challenged the same order before this honorable court, page 30, Annexure 7.
Page?
Page 38.
38.
38, my lord.
Yes, it is there.
Yes, my lord. And page 39 is the order, my lord. Page 39 is the order challenging that rejection order. And finally, observation at page, my lord, page 43, paragraph 11.
Hajira Begum is party.
Party
in
and
that
3,
effect.
respondent number 3,
Three.
CBI 1. So
They could have
paragraph.
brought this before the time of passing of the order. Itu Amar.
Yes. But page 43.
Objection नहीं दिला High Court দিব লাগিছিল Civil Court যোনটো আছিলে order.
আমি নাজানো। Sorry.
Then how we can
Ethical question law.
the court will come to
Paragraph 11, page 4. Yes.
Give you some time.
Yes.
So, my lord, my play, my lord, for stay of the proceeding, my lord, since Jimma has most illegally,
No,
most
stay of
illegal,
proceeding.
Proceeding. Why? Why? Stay of
my
the
lord,
proceeding.
Jimma, my lord, almost illegal manner said ownership is decided.
Stay of the proceeding. Why you need the stay of the proceeding? Why?
My lord, most illegal lordship is.
Other hand, it's okay. I can understand. I can hear your submission
My lord.
that it is the case wherein you were the
I'm the registered owner, my lord.
It is
Yes.
by the CBI.
CBI has
you
not
are
also
the registered-
objected. Yeah, I'm
you
also
are the registered
yes.
owner. But instead of that, one petition was disposed.
Yes, yes, yes.
That is understood. But why you need the
My lord, that's both
Escape.
illegal, my lord. Jimma petition.
but the case why you are there in this case?
Then others, my lord, the CS playing the one-sided money suit for claiming the constitution
Whatever
amount.
that discuss, that is there. This is why do you have filed this criminal revision petition? That
My lord, my humble submission in this case, my lord,
Ah.
since my learned friend represented the CBI already, my lord, respondent to the state of Assam, my lord, as a respondent is concerned, my lord, by prayer, my lord, so record may be, my lord, CBI could record may be called for, and we may be allowed to take justice service, my
you
lord.
don't need the CBI code. Is it necessary?
Yes,
CBI code?
pending, it is pending, my lord.
I don't
It is
think.
pending.
Take CBI. Why CBI code? You want why
My lord,
behind
all the records
CBI
pending
court
there.
order?
It's still pending, my lord. This is-
What pending?
Then, my lord, it is, kindly have a look. That matter still pending, my lord.
What kind of matter is still pending? Jimma matter is still pending.
This is an interim given, my lord. In conditions certain given interim to her, my lord.
By whom? By the learned
CBI
CBI court.
special court.
It's okay. We will call for it.
Then, my lord,
Jimma.
justice
We
service.
have already submitted all these documents.
Okay, then okay, my lord.
Criminal case, justice generally we don't allow. Just pass the order to speed post.
Yes, Mr. Speed and dusty, my lord. We may be allowed.
Huh?
Speed post and dusty service, we may be allowed to take the
Justice is not allowed at the first instance. Heard Mr. P.K. Dekar is an and might run it standing counsel CBI. It is submitted by Ms. Kumar that she needs some 2 or 3 weeks time to get all the instructions from the department concerned, as well as she wants to verify all the earlier order and the order of the civil court. However, she submitted that one Jimma petition was earlier also disposed of by this court, and hence she submitted that it is also to be seen as to whether the present petition is maintainable when one Jimma petition was earlier disposed of by this court, wherein the present petitioner was also made a party respondent number 3. Further, Mr. Petitioner is also hereby asked to issue notice to the respondent number 3 so to speed post and usual process. Let the matter be accordingly listed. After you want 2 weeks will do?
2 weeks. What?
short date, my lord.
Short date means 2 weeks.
After 2 weeks?
2 weeks.
Date may be fixed, my lord. Next returnable date.
16th of March.
Yes, my lord.
You were enabling the petitioner, 6 let the matter be listed, enabling the done this earlier the respondent CBI to file their written objection. Written. Well, listing it on if you have any, or otherwise you can make oral submissions.
Much.
Yes.
It is fixed on 16th.
16th March.
Much of that.
Obliged, my lord.
May it please your lordship. My lord, the petitioner before your lordship is aggrieved by the order dated 6/11/2025 passed by the learned family court Barpeta, whereby my lord, the maintenance of the minor daughters of the petitioner has been enhanced. However, my lord, while enhancing the maintenance, my lord, only the petitioner's income has been taken note of, while the wife's mother's income is also earning 65,000 per month. That was not taken care of. So, my lord, earlier, as per the earlier order, I am paying 15,000 per month as a maintenance. Now it has been enhanced to 22,000. So today I am praying, my lord, lordship will kindly consider, issue notice and stay the order, and earlier payment, as per earlier order, I will be making the payment.
Where is the order?
My lord, order starts at page 100. And observation starts at 109, page number 109, there are 27. Only the petitioner's income has been taken
This
note
was
of.
the petition for enhancement.
Yes, this was a petition for enhancement by the mother. And earlier there was a divorce petition which has been granted, And my lord, the learned court below granted the divorce along with alimony to the wife as well as the minor children. To that extent, a matrimonial appeal is pending where entire thing has been stayed. Now, during pendency of this matrimonial appeal, the mother filed an enhancement petition before the family court. And the family court only taking note of my petitioner's income and not considering the wife's income have enhanced it. So today my prayer is Lordship will issue notice and stay this order, and I'll be making the maintenance payment as per the earlier order, 15,000 per month. The order is starts at page 100. Relevant consideration is 109, page 27, para 27.
What your daughter is doing, she is studying.
Their minor daughters, they're studying in school, my lord. Two
daughters,
daughters, 7,500 each, 15,000 I'm paying, my lord, as per the first order of the family court. Now it has been enhanced to 22,000 without considering the wife's, my lord, income. The wife's income I have given at Annexure 1, bank statement, that she will kindly turn. Annexure 1 page, my lord, it starts at page 18. That she will kindly turn to page 19. Serial number 1, 2, 3, 4, fifth column from the top, my lord. Is earning 64,000 something, almost 65,000 she is earning. That is her bank statement. But this aspect was not at all taken note of by the learned family court. And the impugned portion of the order is at page 110, my lord. Before that, Lordship may peruse para 27. Only my income has been discussed, not the wife's income. At page 109, para 27. May I read, my lord? Admittedly, the second party is now holding the post of assistant executive engineer as discussed in his affidavit on assets and liabilities. It is also mentioned that his present salary is rupees so and so per month. It was submitted on behalf of the second party that he used to pay monthly installment of rupees so and so towards the clearing of his housing loan. It was also submitted that to maintain his old aged mother and his dependent brother so and so and his children. The contention of the second party that he is to maintain his said brother and children is not tenable in the eye of law because he has not a legal obligation to maintain his brother who is a major and married man. The court of law does not recognize the moral obligation but strictly deals with legal duty under section 146 of BNSS to maintain his wife, daughter and parents who do not have the capacity to maintain themselves. Personal loan for purchase of car and other luxury items cannot be considered while assessing the just, proper and adequate maintenance. Also will kindly come to the order. In the result, this case stands disposed of on contest. The second party is hereby directed to enhance the monthly payment of so and so of rupees so and so, total 20,000 per month to his daughter. So no discussion of on wife's income, my lord. So today, my lord, I am paying for a notice and stay of this order, and I will be paying as per the earlier order, 15,000 I will be paying.
You are Mr. Patwar.
J. Patwari.
Hi, Mr. J. Section 438 BNSS, Rated Section 94 against given case number 697 of the issue notice to the sole responsibility and next right submitted Mr. that the earlier the petitioner is paying rupees 15,000 per month for his two minor daughters, but considering the petition for enhancement, the maintenance allowance for his daughters have been enhanced to rupees 22,000 from 15,000, which was paying earlier, which he was paying earlier. he further submitted that while passing the order of an learned principal judge did not consider income of the respondent who is also earning around 65,000 per month, which shows from her bank statement. However, the petitioner is ready to pay 15,000 per month till disposal of the petition, and among this, he prayed to stay of the final order dated 6/11/2025, passed by learned principal judge public order in FC criminal miss case number 697 of the 2024 under section 127 CRPC. Next parent, considering this submission with the execution of order dated 6/11 passed in FC's criminal miss case number 697. We state till next date of visiting, directing the present petition pay rupees 15,000 per month towards maintenance for his minor daughters till the next day. Please demand recording 4 weeks as in the
Deeply obliged.
Yeah, please, your lordship. Lordship, this present application has been filed by the petitioner, been agreed on the order passed by the learned JMFC Lordship Dhofua Khana in an application filed by the petitioner under section 173 subsection 4, read with section 175 subsection 3 of the BNSS. Prayer for a direction to give the direction to the officer in such police station to register the FIR lodged by the petitioner, lordship. Your lordship will find when the application has been filed by the petitioner before the honorable court, the honorable court has also heard the petitioner personally, lordship. Your lordship will find the order at page number 19. Page number 20 is the relevant part where the lordship honorable court has heard and recorded the statement, lordship. May I read, lordship? Page number 20. Upon hearing the petitioner, it appears that on 12/11/2025, the OP Mintu Gogoi entered her house premises and snatched away the file consisting of certain land documents. When the petitioner prevented the OP Mintu Gogoi from taking away the file, then OP Mintu Gogoi pulled and dragged her, and accordingly she was injured on her upper lips and chest. In addition to this, the petitioner states that when her daughter came to rescue her, the OP Mintu Gogoi also pushed her away. Thereafter, on 16/11/2025, she approached the Ghilamara police station and filed an FIR against Mintu Gogoi, but the said FIR was not registered and investigated till that. Subsequently, on 21/11/2025, the petitioner approached the officer in charge of the Office of the Superintendent of Police Lakhimpur, but till that no action has been taken. The petitioner has annexed a copy of the FIR dated 16/11/2025 and a copy of the petition 21/11/2005 filed before the Superintendent of Police Lakhimpur along with the instant petition. Now, your lordship may kindly come to the FIR filed by the petitioner before the police station. Your lordship will find at page number 13. Page number 13 is the lordship translated person, and 14 is the vernacular person of the lordship FIR. May I read, lordship? With due respect, back to state that at the time of preparing our old house situated at part number Hilamara on 12/11/2025 at around 3:45 p.m. all of a sudden a teacher of Hilamara Higher Secondary School, Sri Mintu Gogoi, entered to our premises and snatched the land documents filed from me. When I protested him, he first shot me in my chest, and when I fell down, he dragged me by pulling my wearing seat. When my daughter rushed to save me, then he pushed her away. Subsequently, though we had been rescued by my husband and brother-in-law, but he again involved in a heated argument with us, and lastly,
fled away with my file containing land documents. At that time, though I had decided to lodge FIR against him, but mentally could not prepared me being his sister-in-law. But today morning at around 6 a.m., Mintu Gogoi and the enclosure of some part of the land, Onosutia took advantage of our absence in home and cut down our house and destroyed it completely. Lordship, this is the FIR that has been lodged by the petitioner before the Ghilamara police station. And thereafter, Lordship, the petitioner has also informed the said facts to the Superintendent of Police. Your Lordship will find at page number 16. With due respect, begs to state that when I went to lodge an FIR before the Ghilamara police station on 16/11/2025 at around 12:30 p.m., the Ghilamara police neither behaving me well nor they respond me, and till that they have not even registered my FIR. As a woman, I feel condemned by such behavior at the police station. She has also complained before the superintendent of police. Now, the statement during when the police honorable court has directed the police to appear before the honorable court physically on Lordship the next date fixed on 6/12/2025, that is reflected in page number 21 of my petition, Lordship, and also to give written submission as well as to appear personally before the court and answer the contention raised by the petitioner by petition number so and so. And during that course, Lordship, the petitioner has been requested to the police station for recording her statement, and her statement has been recorded by two statements has been recorded.
How you are agree with now?
Lordship, I agree.
There's so many things. What is your grievance?
My grievance is, Lordship, is that your Lordship will find a page number. Impugned order is, your Lordship will find 12/12/2025.
At page?
Page number 25. Lordship, my grievance is that, Lordship, this application has been rejected by the honorable court only considering the statement of the accused, Lordship, that has been recorded by the police, Lordship. There was not a single witness that has been recorded, nor they have visited the place, Lordship. Only after the direction of the honorable court, the statement of accused, statement of victim has been recorded, Lordship. Your Lordship will find at page number 25. The last part, Lordship. Accordingly, in compliance of the provision laid down under section 175(3) of the BNSS, I have personally heard the petitioner as well as the IO. The OC Ghilamara PS has also submitted his written reply with regard the contention raised by the petitioner along with all the connecting documents. I have carefully perused all the documents filed by the OC Ghilamara along with his written reply. I have also perused the statement of informant and her daughter recorded by IO. Upon careful perusal of the material available on record, it appears that the contention raised by the informant has got no merit, and accordingly the petition is hereby rejected. Lordship, only the document which has been Lordship submitted before the honorable court is only the statement of the Lordship.
Mr. Botaku, it was a petition
Yes.
for registering a case
Yeah,
or whatever
yes, yes.
was not registered. SP was moved to application, and then court directed to register. And it seems that case has already been registered. To the informant and the victim record statement has already been recorded. Now case is under process. Now why? What is the case?
My lord, otherwise, my lord, I have also perused the inquiry report. Inquiry report is at page 38, last page, my lord.
38.
Yes, sir.
Last page 38, my lord. Otherwise, my lord, there is no illegality in the order passed by the trial court. Only thereafter, your lordship may kindly peruse the inquiry report, and the statement of the two victimized persons also recorded. They in fact refused to medically examine, my lord. And thereafter, there is a long pending, my lord, land dispute between the two parties. All those aspects were considered. Where in the inquiry report also, there is no other witnesses. Even neighboring people also, my lord, refused to, my lord, adduce any evidence, my lord. And considering all these aspects, ultimately, my lord, on the basis of the inquiry report, trial court has rejected the petition filed by the petitioner.
But case is still pending before the IO for investigation.
No, your lordship may kindly peruse
Yes,
page
got
38.
registered, in fact,
Page-
lordship.
Page 38. That is the inquiry report, submission of the inquiry. That is the inquiry report submitted by the IO.
Ah.
On thereafter, only by the learned trial
During the
court.
inquiry, it was found that the informant and her daughter minor, however, despite repeated
So
requests,
there is no illegality in the order passed by the trial court. My lord, ultimately,
simple aberration was noted, but whom the important. The accused person caused damage to his house and snatched away the pursuance. No corroborating evidence or independent witness could be found to support his allegations. No visible damage.
The IO has trying to make out a case of
nature. So now that means case there is no cases pending.
yes, there is no case, my lord, against the. So, my lord, thereafter, on the basis of that inquiry report, on the statement of the informant and her daughter, my lord, both were examined. Thereafter, considering all these aspects, the order dated 12/12/2025 passed by the trial court. So, my lord, continuance of this, my lord, proceedings will amount to, my lord, abuse of the process of the court, my lord.
Obviously.
So, this petition, there is no,
Lordship,
this petition is
only
liable
my
on
humble
admission.
submission before this honorable court is that when there is a prima facie cognizable offense that is reflected in the face of the FIR,
All those aspects were
the
considered.
prime duty of the police officer is to, lordship, that if the petitioner is advised to take medical treatment, lordship, then petitioner is not required to approach the superintendent of police. The person who, lordship, recorded the statement after the
What do you
direction
want
of the
now?
police,
What do you
lordship.
want now?
Lordship, since the FIR clearly reflects, lordship, the an cognizable offense, therefore the record of the lower court that may be called for, lordship, upon which the honorable court has rejected the, lordship, petition of the
So these
petition.
are all are before us. only.
Lordship, in this petition, lordship, if
That
your
about
lordship,
what is the you have already submitted the court, rather court recorded
Yes,
the
your
statement
lordship,
of both the witnesses, the victim
but
and the
the-
Yes,
informant also his
statement of the, lordship, victim,
Ah.
lordship, completely reflected there is an assault and trespass, lordship, that cannot be denied by the lordship IO before investigation of the case, lordship. They have not in fact registered the FIR, not in fact response to the FIR lodged by the petitioner at the initial stage. When the lordship, the petitioner has approached by filing this application under section 173 subsection 4, then only lordship police has recorded the statement of the petitioner, and without they have not in fact visited the place of the occurrence, lordship, nor any statement has been recorded, statement of witness has been recorded, lordship.
So this is clearly indicated in your
yes,
application.
only
There is
because,
no
my lord,
witness at all.
only
There
because
was no
initially.
witness, lordship.
Witness. So what
Lordship,
police will record?
Police has not in fact visited the place of occurrence.
That is
They,
your
My lord,
they
only
cannot.
because
your
initially,
allegation.
only because
Lordship-
initially police has not registered the case. Therefore, my lord, by order dated 25/11/2025, Lanet Trial Court has in fact, my lord, ordered personal appearance of the IO
Hmm.
on 6/12.
Hmm.
Thereafter, my lord, on 6/12, IO appeared personally and submitted, my lord, his written statement. Thereafter, on 12/12, my lord, inquiry report was also submitted and in detail, my lord. And thereafter, my lord, the statement of the victim and, my lord, the informant, all, my lord, all statements were considered, and thereafter, on the basis of the inquiry report, in fact, the petitioner was appeared personally, my lord. Petitioner was also heard in person by
Yes,
the
hard in
trial
person.
court.
Hard in
Yes, sir.
So, my lord, there is
Lordship, the
nothing also.
statement of
The
the
continuance of this proceeding will amount to abuse of the process
Lordship,
of the court.
whatever
There
the
is
statement that has been
absolutely
recorded
nothing,
by
my
the
lord, in
police
is there.
under section 180, lordship, it completely clearly reflects the commission of a
There is no
cognizable
case at
offense,
all
lordship.
against you, in fact. No case. What to do?
Lordship, at this stage, Lordship, notice may be issued upon the Lordship.
Notice
I-
is for issuance of notice, there has to be something.
Lordship-
Nothing is there.
Lordship,
It
it
is a
cannot
case
be
after
denied
it
that,
can be rejected.
Lordship,
No,
it cannot
nothing
be
is there.
denied that there is no presence of any commission of cognizable offense in the face of the FIR, Lordship. In fact, your Lordship will also find when the statement, two
You
statement
are
has
going to appear for 1, 2, and 3, Mr. Kothakot.
Yes, my lord.
You can appear 1, 2, and 3, na?
Your lordship may kindly peruse the,
No, you can appear for 1, 2, and 3.
yes.
Respondent.
Your Lordship may kindly take up the matter in any other day. I will satisfy your Lordship to the extent,
1, 2,
Lordship,
3.
because the Honorable
Yes,
Supreme
my lord,
Court
I can appear on behalf of 1 to
in the case of state of Madhya Pradesh, Lordship, there was a
Your
clear
application
direction
is
that
there.
if the
What is there?
Lordship, if the London magistrate receive a complaint of any cognizable offense, in that case,
And
Lordship,
is
it is
there
the
any
duty of the
necessity for
magistrate
call
to
for any record of, because these are all leading.
Yes, all are there.
No, statement you need
The
the
statement only two statement, victim and my lord, to both victims, my lord, informant
fact-
and her daughter. Statement already annexed inquiry.
How, on what basis record will be called for? There is no case.
And in fact, there is no injury, my lord, in that, but that was.
No,
in
it's
fact,
okay, but there is no case, na? How it will be called for now? What record will be?
Yes, my lord, because that case, my lord, already that was
A simple
rejected.
an order passed by the court. There is
Yes.
no restriction. Definitely, there won't be any restriction.
Yes, yes.
Simple direction is there.
Lordship,
Court of the, my lord,
What kind of record you want to now?
if your Lordship will see the
What kind of record do you want now?
Lordship, what any other documents that has been relied by the petitioner which has
How-
not
now,
furnished to the
on what basis
here,
it will be
Lordship,
called for?
Lordship, no, in the order, Lordship, it has not been reflected that on
No, on what basis it will be called for now? There is no case reference, nothing is there, na?
Lordship is there, Lordship, petition number 908 of
Petition
2020.
number.
Yes, Your
Where's the
Lordship, because
case?
this is the process, Lordship,
Where's
that
the basis?
this application can be filed as a miscellaneous
Ah,
petition,
yes, yes,
Lordship.
it can be, but it cannot, it is not registered as a miscellaneous case.
Lordship, miscellaneous case has been registered. It was
Where? Show me.
Your Lordship may kindly see first it was registered and ordered on 25
page
11
38,
2025.
enclosed document,
has
5,
not
page
been-
38, last, my lord, that is serial number 5, copy of Ghilamura PS, non-FIR, part 2, case number 7, 2025, under section.
Honorable Court has
These are all produced before the learned trial.
Yes. all are put on it.
Now, how it will call for now? On
Yes.
what basis? There is no case
No,
reference,
no,
that's
no.
what I'm saying.
Otherwise, my lord, from the
How it
materials,
will be called for?
my lord, only that non-FIR case, my lord, that order from the,
Order of so and so.
yes, my lord. That non-FIR case, my lord, which was disposed of
Because there is nothing, na? That's
by the court of the learned judicial magistrate first class, my
Dokwa Khana, na?
lord, Dr. Khan.
You are Mr.
the sir, my lord.
Heard Mr. D. Sharma, the learned counsel for the petitioner. So heard Mr. P. Water, so and so. This is an application on section 528, April section 438, 442, PNSS. Assailing the legality and validity of the impugn order dated 12/12/2025, passed by learned JMFC Dhokwa Khana, Lakhimpur, whereby the application number 1908/2025, filed by the petitioner under section 173, subsection 4, April section 175, subsection 3, BNSS, was rejected by the court. Issue notice. The respondents, no formal notice is required to be served to respondents. Let the records, inquiry report and the other relevant documents which were furnished before the learned court of JMFC, Dhokwa Khana, while passing the order on the petition number 908/2025, be called from be called for the estimator accordingly after 2 weeks as on a date. Listing it after 2 weeks, but there is nothing in the here.
Case diary may be called for because the police has recorded the statement, Lordship.
No case diary.
Yes, Your Lordship. Because the police can record it only on the
All
basis-
relevant documents. I
Record
have
everything will come
every
in
copy
the
come.
record.
We have already after 2 weeks.
I'll apply.
May it please your lordship.
Yes.
This is an application under section 528 of BNN assess for seeking pausing of the proceeding initiated under section 146 of BN assess. Under 146 proceeding, that is alteration of allowance. In that proceeding, entire family members has been made a party. There is a earlier round of litigation also. I would like to take your lordship in the earlier round of litigations, my lord, which was proceeded under section 125, my lord. Page 44, my lord. There was an ex parte order judgment by the learned principal judge, family court, Gauhati, my lord. Page 44, my lord. The judgment is dated 1/7/2022.
Yes.
It starts from page 44. Yes. My lord, the relevant portion, page 54, my lord. My lord, before that, just one sentence, my lord, one paragraph at page 44. This is an application under section 125 CRPC filed by the petitioner Srimati Swapna Roy, seeking maintenance allowance for herself and her minor son from her husband, opposite party, Sri Prabodh Bhatta. Now, page 44, the finding of the learned principal judge. The second paragraph, my lord, in the middle portion. It is well settled that where a man and woman have been living together as husband and wife for reasonably a long period of time, strict proof of marriage should not be precondition for maintenance under section 125 CRPC. There is also no iota of evidence that the petitioner lived with the opposite party together as husband and wife for a certain period. Her evidence is only that due to having physical relations, she gave birth to a male child, and also she spent one night in Ceylon with the opposite party after birth of her son. Except that both the parties reside in their respective houses, as such the ruling relied by the petitioner is not applicable. Now the operative part of the judgment, my lord, your lordship will find at page 56. In the result, number one is, my lord, important. In the result, the petition under section 125 CRPC filed by the petitioner is partly allowed ex parte. The opposite party is hereby directed to pay an amount of rupees 12,000 per month to the petitioner from the date of order, that is from today, my lord. So, my lord, the facts is that there was an illegitimate child, my lord, through Sapna Roy is the mother, my lord. When this person, Prabodh Bhatta, my lord, came to know about this proceeding, my lord, about this judgment, ex parte judgment, he preferred a criminal revision petition before this honorable court. And this honorable court was pleased to stay the proceeding, my lord. Page 59 is the, my lord, the relevant. Page 59, my lord, annexure E.
Yes.
Criminal revision petition 370 of 2024. Parties are Prabodh Bhatta and versus Srimati Sapan Roy, my lord. This application, there was a delay of some days, my lord, that was condoned, and thereafter this criminal revision was taken up, my lord. So at page 60, the relevant part, the last paragraph.
Yes, 60
Till
days.
returnable date, the impugned ex parte judgment dated 1/7/2022 passed by the Principal Judge Family Court, Kamrup at Guwahati in FC criminal case number 264/2020 shall remain stay. Thereafter, what happened, my lord? This person, Prabodh Bhatta, died during the pendency of this criminal revision petition. Accordingly, that matter was closed by this honorable court. Your lordship will find the annexure F next page, that is page 61. Page 61 starts. The relevant portion is at page 62, para 3.
Yes.
Paragraph 3, my lord. It is submitted that the learned counsel for the parties conjointly, my lord, both parties, that the petitioner during the pendency of the instant criminal revision petition has expired in the month of November 2024. As direction made by the Learned Family Court in order dated 1/7/2022, case number 264 of 2020 is specifically to the petitioner, there is no live issue surviving after the demise of the petitioner. As learned counsel for both the parties have submitted, both the parties, my lord, have submitted that the petitioner has expired and the case has become infructuous, the instant criminal petition is closed as the same cannot be further adjudicated, my lord. So, my lord, it was in person against that particular person, that 125 proceeding. 125 says that it will liable, it will be against the father only, my lord. So it cannot be further adjudicated. Now, after 3 months of this passing of this infructuous order, my lord, the Sapan Roy, through her son, that is Prashanta Bhatta, has filed a proceeding under section 146 for alteration of allowance, that is, my lord, for enhancement of the maintenance, my lord, making all the family members, that is number one, my lord, will find page 65. Pinky Bhatta, the legally wedded wife of late Prabhat Bhatta, my lord. Then page 66. Srimati Sirpa Bhatta, mother of late Prabhat Bhatta, my lord. And 3, 4, 5 and 6 are the brothers of late Prabhat Bhatta. So, my lord, my humble submission is that this proceeding is misconceived, my lord, is not maintainable at all against the person she has made party, my lord. Because, my lord, 120
on this petition, whether any proceeding is initiated already?
Against which, my lord?
Proceeding is initiated again now?
No, this proceeding has been now after the Honorable High Court has said that this earlier judgment has become infructuous. It is
okay. Now on the
now
basis of
this new fresh proceeding has been started, my lord, at
Yes,
page
yes.
63, my lord.
60?
63. Miss case number 522 of 2025.
No, any order is there? Is there any order?
No,
This is a petition.
just notice has been issued. We have appeared and we have taken time, my lord. Now, after taking time, obtaining the certified copies of all the relevant papers, we have approached this honorable court.
This miscase is 522.
This case is miss case 522 of 2025. So it is misconceived, my lord, because this petition is not maintainable against the legally wedded wife of Prabhat Bhatta and the mother and the brothers, my lord. Because, my lord, 125 says, I would like to take your lordship 125. No, Purana 20. (125) of CRPC, man.
Yes.
May I read 125 project? Now it is corresponding to not in section 144. New section has been, my lord, corresponding section is 144. Since the earlier proceeding was initiated under section 125, that's why I'm referring to 125. Order of maintenance of wives, children, and parents, my lord. If any person having sufficient means neglects or refuses to maintain his wife, his legitimate or illegitimate minor child, whether married or not, unable to maintain itself, his legitimate or this will not. So, my lord, he is referring to his, that is father, my lord. That is biological father, my lord. The respondent number 1, that is Pinky Bhatta is not a biological mother, my lord. So earlier round of litigation, this honorable court has rightly held that it has become infructuous, my lord. And it was specifically to the petitioner, and there is no life surviving after the demise of the petitioner, my lord. My lord, I would like to rely on one Kerala High Court of Kerala, my lord. There is one Supreme Court judgment also, my lord. Paragraph 6, second page, my lord. May I read it? Title to Section 125(1) CRPC being order of maintenance of wife, children, and parents, the person responsible to pay it under the provision would naturally be the husband, father, and children, my lord. The provision does not bind the grandfather to pay monthly maintenance allowance to the respondent number 1 and 2 who are his grandchildren. Claim for monthly maintenance allowance can be made by the respondent number 1 to only against their father. Here to legitimate children, but here it is an illegitimate children, that is, he can claim maintenance against the biological father, my lord, and not against the mother, who is not at all mother, my lord. So at this stage, my lord, that proceedings may be stayed, my lord, and the matter may be examined, my lord. Totally misconceived, my lord. My lord may have my ground 6, page 13, my lord, my ground number 6 and 8, my lord.
Where you have received the notice?
I have received the notice, I have stated, my lord, recently. Paragraph 8, my lord. The petitioner aware, paragraph 8, page 9, my lord. The petitioner were, may I read it, my lord? The petitioner were absolutely unaware of the aforesaid fact and legal development taken place. However, the petitioner recently received notices from the learned principal judge family court number 1 at Gauhati, along with the copy of the petition, namely Miss Case number 522 of 2025, arising out of so and so, by the respondent on behalf of her minor son, Master Prashant Bhatta, under section 146 of the BNSS, asking them to appear on 29/1/2026. Well, very recently. The first appearance was at 29/1/2026. So immediately we have come over, man.
Part Mr.
BK Singh, ma'am.
Casing petition. This is an application, section 528 PNSS. Second, quashing of the proceeding initiated under section 146 of the PNSS. 2023, pending before the court of learned principal judge family court number 1, Kamrup Metro, which is registered at Miss Case number 522 of 2025, arising out of FC criminal case number 264 of issue notice to the sole representative, sole respondents through his legal representative, and also copy. Next, right, is submitted by Mr. Singh. The initially 125 proceeding was initiated by respondent Swapna Roy, seeking maintenance from one Walpurto is one Prabhu Bhatta, which was registered as FC criminal civil case number 264 of 2020, wherein an ex parte order of maintenance was also passed in favor of the respondent Swapna Roy against the said order, wherein it is stated that she was staying with said Prabhu Bhakta as a wife, and out of there, and for which one child, namely the respondent Prashant Bhatta, born. And considering this aspect, the court already directed the petitioner, said Prabhu Bhatta to pay maintenance of rupees 12,000 per month. Agreed to the said order. The petition present, but the agreed to said order, said Prabhu Bhatta filed an criminal revision petition. But during the pendency of the said criminal revision petition, he died, and accordingly, the said criminal revision petition was also closed with an observation that as the petitioner already expired, the case become infructuous, and the case become infructuous as the order of the family court was specifically to the petitioner said Prabhu Bhatta, and after his death, there is the entire petition has become infructuous. But thereafter, the respondent Swapna Roy through her minor child had initiated one proceeding under section 146 PNSS before the Court of Learned Principal Judge Family Court, Kapur Petro, which is being registered as 522-2025, arising out of FC criminal case number 264. Wherein all the petitioners have received the notices for their evidence. If further submitted, these petitioners are not responsible for paying maintenance to the son of the respondent Swapna Roy, who was also neighbor, and the Swapna Roy, and no liability is raised upon these petitions. Accordingly, he submitted that the proceeding initiated under the Miss Case 522/2025 may be stayed till disposal of the present criminal petition. Considering this submission made by learned counsel for the petition under circumstances of this case, further proceeding in Miss Case number 522/2025, arising out of FC criminal 264/2020, be stayed till next accordingly after 4 weeks as amended.
Obligement.
Yes.
Yes, Your Lordship. This proceeding has been initiated on the basis of an FIR filed by one support person regarding a minor girl
Hmm.
was at the FIR at page Your Lordship at 23. The support person got the information that a minor girl has been pregnant, and therefore accordingly she has filed this information before the police.
Hmm.
And
It's a
on the
case
basis
of child marriage.
child marriage along with POCSO section, Your Lord.
Whatever, child marriage is
Yes,
there.
yes, yes. The child marriage is in thereafter FIR was registered under relevant provisions of POCSO Act as well as Child Marriage Act. Here, what happened, Your Lordship? The girl who was stated proceeding to approval.
Boxer is there also notice will go first.
Notice will go.
Notice will go. There is no dispute that I have not complained that. My case is that I am the doctor. I am the doctor, registered medical practitioner and gynecologist, and working in Eastern Nursing. On 16/7/2025, the patient with bleeding and heavy pain admitted in the hospital. Thereafter, some spontaneous expunging of products has been taken place. The doctor has treated the patient. Now, our allegation against us is that under section 21 and MTP Act 5 for illegal abortion and for not informing the police regarding commission on an offense.
No, but yes, this is the law now.
Your Lordship.
Why you did the MTP without informing anyone?
Not
without following the
no.
legal
That
procedure?
is the miss wrong. We have not done MTP. She has came to the hospital with heavy bleeding and
yes.
pain.
Hmm.
That is not NTP has been done. Abortion has not been done. It is a spontaneous project, a spontaneous expunging of product. The doctor admitted heavy pain, bleeding. The product has already been damaged. So we have only treated, saline has been provided, then and after some time at 5 o'clock, etc., the product has been expanded. We have not done abortion. That is the wrong thing has been going on. We have not done abortion. That is the main problem. And regarding the doctor's liability, treatment, etc., in the medical prescription, the girl was accompanied by
Who
her.
brought the girl?
Huh?
Who brought the girl to your hospital?
The husband, her mother, and mother-in-law. All the 3 persons are there. In the medical admission report, we have also enclosed it here. See, their age was written at 19. Age was written. And regarding doctor's liability, there is I have seen a case law, Dr. Tessie Jose and State of Kerala Supreme Court has specifically stated that doctor is not responsible to verify all these things. So I want to place that judgment after it is very clearly stated.
So what is the stage of the case at present?
It is in evidence stage.
So
So
you
my view is
waited
that
till evidence.
Yes, you'll see.
You waited till evidence.
No, it is only shortly started after
No, at the
framing
time
of charge.
filing the charge sheet or at the time of the
No,
it
not
would have
charge.
come.
We are trying to get rid of the framing of charges. So charge has been framed against us. Therefore, we have approached this honor.
You prayed for discharge.
Discharge.
That was rejected.
Rejected.
You have order replaced your order here?
At 39.
39. No, this is the framing of charge order.
That is the framing of charge. We have filed an application that has not been discussed by the honorable court at all. That is also.
No, that won't do, and one officer won't do that. If
We
you
have
have
filed-
submitted,
we
your
have
petition number is there.
Yes, we have filed a petition under 250 BNSS there.
Yes, that petition was there.
Yes, there.
It was numbered also.
Yes, we have filed on.
You have to call for the record. Otherwise, court generally won't do these things. Because if you have
That is that for our grievance is also that. That is nothing has been mentioned and grounds, no reason has been given for framing of charges. Because under 21 POCSO Act 19(1) is the section, we have to inform them. The age is written as 19. So how the doctor will know that whether he is minor or and they are
21 says 21 is abatement, I think, no?
not abatement. It is actually it is duty bound to inform the
21.
21 is the punishment. Actually, 19(1) is the section.
POCSO, under POCSO or?
POCSO. Reporting of offences, 19(1).
So against you, only 21 has been framed.
21 and MTP.
21? 21?
And MTP Act 5 is.
Yes, MTP. Anyway, yes, Mr. Locker, what to submit?
So notice may be issued. I have no objection, but against me, it was fixed on 24 for evidence. Against me, maybe state, and I want to place the decision, your lordship. If your lordship, after going through the decision,
That will, I have no objection. But lordship, when there is a specific observation of the Honorable Apex Court that notice has to go before any effective order. So lordship, at this stage, lordship, because POCSO is there, lordship, then I cannot say.
No, it happens. There may be some cases where the spontaneous abortion may be there. It not required there's any MTP, may not be
But
required.
whether there is any documents,
Spontaneous
lordship, but
abortion only, it may be
whether
there.
there is any documents that they have enclosed her name is lordship as 18 years person.
no, my admission card did issue, or person not to issue, or statement of victims has been also provided here.
Provided where?
In this case here. In
Here
case,
you have annexed here?
yes. Victim statement has been in page number 43, original. Assamese person. She has also not alleged. She herself stated that
One is
43.
No, they will not brought allegation against you. Why they will brought? I'm saying the note of your medical register where.
Oh, yes,
are
operation note
the
has been provided. Operation note has been provided. Operation note is in page number 28.
28.
8.
আনি থব কোনোবাই লৈ গ'ল মোৰ তাততো নাই কিন্তু নাজানো থাকিব পাৰে
The operation note, it is specifically states spontaneous expunging of product.
So days kiman tayo?
Apollo 16 or something.
heard Mr. You are Mr.
H.C. Sharma.
Heard Mr. H.C. Sharma, the learned counsel petition. Also heard Mr. P.S. Lockhart, the learned additional 58 million state responsibilities in application of section 528, added with section 438 BNSS for setting aside and quashing against the criminal proceeding initiated against the present petitioner, wherein the charge is also framed against the present petitioner under section 21 of the POCSO, as well as section 5 of the MPP Act 1971. Issue notice to the respondents through speed post and usual process. No comment of this is required from the state but the copy of the petition may be served during the course.
One is the two provide number again.
Further, considering the submission made by and council petition and the circumstances under which the child of the pregnancy of the victim had to be aborted, etc., as well as the medical note and admission card. The further proceeding, the further proceeding initiated against the present petitioner be stayed till next date of listing. List accordingly after 3 weeks as an date. Obviously, it is a case of thing, but considering the other circumstances, law court stayed the proceeding of doctor against the doctor. Because admission notice we have seen, she was brought in a very serious condition because otherwise she was 5 months pregnant, in fact. So in the 5 months pregnancy, if there is such kind of things that is very serious for the health also. Otherwise, she could not be survived also. That is some conditions are there. So that's why we stayed the proceeding against you. After 3 weeks.
528 BNSS we are challenging learned trial court order whereby issued at first NBWA and subsequently PNM. POCSO is there. At this stage, I am praying for only notice and kindly call for the decision.
Your Lordship may kindly peruse my lord last page of the trial court my order earlier passed by this honorable court, page 91, my lord. Page 91, my lord.
91.
This all are absconders, my lord. Here. Page 91. Since the search sheet has been filed, the person whose name appeared in the search shall appear before the trial court within next 10 days from today for seeking regular bail.
Thereafter, they
POSCO, yes.
POXO is there, my lord. And then before charge sheet, my lord,
Offense is
there,
very serious. POSCO
before
is
charge
also
sheet, there
there, my lord, and there
PR is bill, my lord.
case is registered under section 64(2)(m), my lord.
Or is
All are absconded, my lord.
POXO is there.
Cognizance already taken.
AB. Regarding those, I have explained
So
in my
ultimately,
petition.
without getting any relief from the my lord, trial court, they approached by before this honorable court again by way of this criminal petition, my lord. So first, my lord, while there is a direction for of this honorable court to appear before the trial for seeking, my lord, regular bail, my lord, without obeying that order of the trial court, they again, my lord, taken recourse of this criminal petition, my lord, only to get the protection, my lord.
On that regard, my lord, I have explained in my petition at para 19. And in addition of these, my lord, in this case, London trial court issued at first NBWA, my lord, without properly serving of someone, my lord. Before properly serve someone to the accused persons, my lord, NBW issued. And I have annexed with my petition someone and along with someone service report also. I will explain on those points on the next day. At this stage, kindly confirm.
Administrative duty and responsibility petition. Report. Item number 7. Report. Yeah, snappitions. 306 2025 passed by Petitioner Spock, not Salman Factory. Whereby non-bill warrant of which issue notice to the respondents to speed post and usual process. Also call for the scan copy petition. No comment is required. Based matter accordingly. It has to come from which place?
My lord, from
Not
Bhopal.
Kalmara Abhayapuri Moyagaon.
Not Marhab. Your next date is fixed on when?
Next date, my lord. I'm sorry, I'm not checked. After 3 weeks at any date, my lord, kindly give me. 18 of March. I'm always.
May I please. Charge cash lordship, there is also POXO lordship. As this is notice may be issued lordship and call for cash. Simple another pairs lordship in pair number 2 and 7 lordship. In advertently lordship, petition number 1, it ought to be petition number 2 lordship. That may be allowed to correct lordship. The number lordship.
Petition number 1 is 2. Means petition number?
1. Pair number 2 lordship.
Para number 2.
2. The petition number 1, it ought to be petition number 2 lordship. And
Petition number 2 is the father.
Yes, lordship. 2 is the father.
Okay, you make a submission. No, it's okay. The minor thing, we'll make it.
In pair number 7 also similar mistake is done.
Well, your lordship may kindly come the synopsis, my lord. Next date is fixed for appearance on 7/4/26.
7.
And the petitioners duly appeared before the learned trial court through their engaged counsel on 16/9. Your lordship may first page, my lord, synopsis, my lord. The petitioner, my lord, duly appeared before the learned court through their engaged counsel on 16/9/25 and 9/1/26 respectively by filing adjournment petitions showing cause, and same were allowed by the learned court fixing the next date on 7/4/26. So, my lord, where is the need of filing this petition, my lord? Already he appeared before the trial court, adjournment petition filed 2 times, my lord, and next date is fixed on 7/4/26.
Yes.
So, my lord, this petition is liable to be rejected.
What you have filed?
Lordship, there is a POXO lordship and there is 65(1) lordship, textual lordship. At the time of trial, investor lordship, the petitioner shown absconder lordship. There is the problem, lordship.
2 times they have appeared, file adjournment petition, trial court has allowed, and next date is fixed
Engaged
on
advocate
7/4/26. And now, my lord, they are my lord, by way of this criminal petition, they are trying to delay the matter, and my lord, ultimately, indirectly, they want to get protection by way of this criminal petition. So that amounts to abuse of the process of the court, my lord, while already trial court has passed orders on 2 occasions, my lord, allowing them to appear thereafter. So let them appear on 7/4/26 before the trial court.
Yes, Lordship. They
And
will
thereafter, if
only
trial
that
court reject, then
prayer Lordship allowed to, if they file petition, bail petition,
these are
that may be
matters-
considered. That is my prayer Lordship. Nothing else. Only that prayer Lordship.
how that
On
can
the
be postponed
appearance,
matter,
that
my
may
lord.
be allowed Lordship. If file the bail
My
petition.
lord, that
This is the
order,
prayer
already
Lordship.
trial court has passed an order my lord, fixing date on 7/4 for their appearance, my lord. So trial court will pass appropriate order in accordance with law, my lord.
That's
So
what
now,
he is seeking.
Yes,
can be
that is my prayer Lordship. On the appearance, that may be considered Lordship. If file bail petition, that is prayer Lordship. They will be ready to pay the trial Lordship.
trial
Already
court
they
will, my lord,
appear
while
Lordship.
bail case is already fixed on 7th trial.
7/4 Lordship. They will appear on 7/4, and if they file petition, that may be considered. That is my prayer Lordship.
That may be considered in
Yes,
accordance with
Lordship,
law.
that may be considered.
You are Mr. J.U. Emmett. You are Mr.
Yes,
J.U.
Lordship.
Emmett. I heard Mr. J.U. Emmett, the learned counsel. Mr. Report. Then application under section 528, section 58 PNSS. So what is your prayer here in this case? Exactly.
Yes, Lord. On their appearance, if
There's
they file
nothing
bail
in
petition,
your
that may
cost
be
title
considered.
also, huh?
On their appearance, if they file bail petition, they may be considered.
No. Where is your prayer? What is your prayer?
Yes, Lord. Page number 10, Lordship. 9. 9, 10, Lordship.
No, you are not agree with anything, any order.
No, Lordship. There is
No, my lord.
apprehension is that, Lordship. There,
My lord, already trial court has fixed, my lord. In fact, he has appeared on 2 occasions before the trial court.
Yes.
He has filed adjournment petition. Thereafter, my lord, trial court has, my lord, considered his, well, the adjournment petition. Thereafter, my lord, case is again fixed on now, my lord, on 7/4/2026 is the next date fixed for his appearance, my lord.
Now, yes.
And now, my lord, while
Five
matter is
25,
pending,
which again, which order, which
no, Lordship, they,
What is it?
they file and adjournment petition through engaged
frivolous
counsel, Lordship.
petition,
Not the
liable to
solicitor,
okay,
Lordship.
engaged counsel at
Their
that
apprehension is, Lordship, in the charges, they son absconder and
I can
subsequent
understand,
non-bailable
but
section, Lordship.
which order you have filed it this 520A?
Yes, Lordship.
What to set aside, what to quash, what is the order?
Only direction,
Why?
not to set aside. Direction is on their appearance.
absolutely, my lord, frivolous petition liable to be rejected, my lord.
No, Lordship.
Listen, nothing. Now see,
No, Lordship. They are ready to appear, Lordship. Only they 2 times filed the adjournment petition through engaged counsel. They not personally appear because, Lordship, they in
I
the
can understand. They
Yes,
are
Lordship.
just they were shown as an absconder.
Yes, Lordship.
So through engaged counsel, you have file petition, so that NBW may not be issued. It's okay.
Their
Now,
apprehension is
I'm
that,
just
Lordship.
saying, Mr. Bottakor is asking, now this petition, why, to what to set aside, what to quash, what order,
Lordship,
what is the order?
Lordship, being non their apprehension is that there may be
What is
arrest.
where is the order? Where is the order?
There's no order, Lordship.
Then what we will do now?
There is the apprehension, Lordship, because
Sorry?
Well, where is the man? This type of petition is liable to be rejected with even with cost.
apprehension, Lordship, that is why, Lordship.
Only trial court has fixed the next date for appearance.
They will be positively
Without,
appeared,
how he is
Agree
agreed?
with anything you are not supposed to win, and then why you have filed this petition? Your all the petitions were allowed. Not even NBW is also not issued against you because
Lordship,
procedurally
Lordship,
it has gone.
only for apprehension, Lordship, they may be detained, Lordship, because in
No,
investigation, Lordship,
are
shown
agree
absconder,
with
Lordship.
which order? You are agree with which order? What to under 528? What to be set aside? What to be quashed? What to be reviewed? What is the order?
Lordship,
There's nothing, na. Just
only,
I'm looking
only,
into where is the order?
only protection, Lordship, on the appearance, if they file petition, that is my prayer, Lordship. Nothing.
What kind of submission, my
Only that is my prayer, Lordship.
So and so 528 because 430.
Lordship, only the apprehension, Lordship.
Surprisingly, there is nothing in the record as to under which order they got aggrieved or to be set aside or quashed by the present petition. Further, from the record, it is from the submission and the record, it is seen that the petitioners were shown as an absconder in the case wherein they have filed 2 adjournment petitions which were allowed by the court, fixing the next date on
7.
7
4,
2026 for their appeals. Mr. Bhattakur submitted in this report that there is nothing to be entered in this petition wherein their adjournment petitions were accordingly allowed by the learned trial court below, and the next date is fixing on 7/4/2026 for their appeals. Thus, there is no order wherein the petitioners are agreed to entertain the present petition or to pass any order. In view, after hearing the submission made by learned counsel, it is seen that that petitions were duly represented by the learned and this counsel in 2 occasions before the learned trial court below, which were accordingly allowed. And next date is fixed on 7/4/2026 for the appeals. Till that, there is no order of issuance of any NPWA or warrant of arrest against the present petition to be agreed. However, considering the submission made by learned counsel for the petition, all the petitioners are hereby asked to appear before the learned directly to appear before the learned special judge with an appropriate application for bail, which may be considered in accordance with the above observation within petition stands disposed.
No bless.
Yes.
This quashing petition I filed, my lord, against the procedure of under 138 in Act, pending before the learners JMFC 1, Kamruk Metro, Gauhati, number 451/19. There are a lot of points involved in it, my lord. There are a lot of points involved in it. I have to go one by one. What are all the lacunas? First,
Okay, we are not going to hear the entire matter. The question is that your petition, you are agree with the order of 6/7.
6/7.
6/7/2018.
No.
What?
Now I agree by the order. Cognizance. Cognizance is taken off page 1, page 21.
21.
Page 21. Yes, 14/12/23, I have agreed by the order. The petition begs to submit a 14/12/23 respondent complaint has filed an initial deposition evidence of Sri Jyotindra Kumar Sinha. Then after procedural complete evidence and affidavit document exhibited by the auditor was pleased to issue someone upon the accused petitioner. So this order itself is bad in law because when the cognizance was taken, a lot of irregularities there which they have not followed while taking the cognizance. First, my lord, I can just tell you about the legal notice, which is very much mandatory to serve legal notice upon before when the check was bounced, we have to issue legal notice. That legal notice was not issued. They have only issued, there are 5 complainants, accused. Out of which they have issued only on 3 accused, 4 accused. 1 accused, main accused is they have not served any notice. I can show you, my lord, if you will also go through the place. Complaint.
No, who are you? You are the main accused, or?
I'm the company. Madhukan.
You are the company.
Yes, I'm the company. They have not issued, they have no notice of serve. 138 clearly says that. 138, I just read out. The payee or the holder or the due course of check, as the case may be, a demand for payment of said amount of money by giving notice in writing to a drawer of the check within 30 days of receipt of the information by him. So he has to serve notice, 138B. That is not compliant. And the court has taken cognizance. 1. Second, my lord.
What is the stage of the case?
My lord.
Because cognizance has already been taken in 2023 itself. So what
Yes.
is the stage of the case at present? At present, what is the stage of the
What
case?
was the appearance?
Still now appearance?
Still now appearance.
Oh.
Because there are a lot of lacunas there. Only we have come to know recently that someone has been issued against us.
Have you annexed the orders here?
Yes, I have annexed all the orders.
How it can be possible? In the case of 138, cognizance has already been taken in.
Because that's not delivered. It is once it is filed in Gauhati, it shifted to Morigao. Morigao, the complaint is absent for lot of days, so many days. They have remained absent. Ultimately, the case has been filed. Without filing any revival petition, they have filed. Without revival, the case has been sent back to the complainant. Then you go and file and hand over to the brief to the complainant. You go and file with the Gauhati because we have no jurisdiction. So this is where the time is passing out. No procedure, just hand over the brief. How is it possible?
Let's forget about the other accused person against you. The notice was issued.
No.
Huh?
Not yet.
No, notice, yes, and 138 notice is there against you.
No, 130 notice is not served on me. Page 86, if you go through a page, evident legal notice 86 page, you can go through the page 86. Page 86. I just demand notice. 1, 2, 3, 4. Main Madhukan Project Limited was not there. But in the complaint petition, you will also go through the complaint petition, page 59, you will find there Madhukan is the main complainant, accused. Complaint is the main accused. Number 5, complaint petition.
But all the directors were issued notice.
All the directors issued it, but company not they have served any notice.
Huh?
They have not served any notice, 130 notice. Main
The
company
is represented by whom? So
by
it should
directors.
represented by someone.
Yes.
So who is the company represented by whom? Represented
Managing
by the
director.
principal officer.
Principal officer. This is one aspect. One aspect I'm telling you. There are other specific allegations, but so for the company's part is concerned, my lord, there is a lot of judgment is there that you have to file a specific allegations that all the directors are responsible for issuing the checks, which they have not mentioned here. They have not stated specifically that directors are responsible for issuing the checks. The question of high court is like how it comes. Because there are a lot of, if you also go through that complaint petition, you will find, my lord, in para 2.
We are not going to pass any stay order here. We are just issuing notice.
But my lord, it is not stay order is not given, my lord. Then in that case, my lord,
only take cognizance
for a time being, stay order may be given till the next day. Till the next day.
Because all the directors and the company executives were already served with the notice only.
Yes.
And you are not saying who are you.
And
you
the
are
case,
company may not be, you are represented by these persons. Those persons were already served with the notice. You are represented by the director, principal officer, or the manager, whatever.
Yes.
These persons were already served with the notice.
And in the meantime, what happened, my lord? There why are you telling Madhukan is necessary? Because all the directors, they have all retired. A specific name, all directors are retired.
That will come later.
Yes, that's what telling
the relevant time of incident, you are there, na?
Yes.
So you are personally.
No, but in the complaint petition, they have not specified anything, specific allegation. The directors are issuing the checks. Madhukan is issuing the checks, they have written. Company is issuing the checks, no director specific allegation. So what the time being, let the
signatory is there, na? Represented by the signatories are already.
And my lord, what is the defect? Another thing, there the case has been restored without revival petition. Once it is dismissed. And not
tell about your own case.
And they anytime we hand over to complainant, even not transferring, my lord. So in that time being, let them file an affidavit, and for time being, let the date it
matter. It's a formal party here.
Yes, that is a formal party.
Want to submit it? Yeah.
For the time being, for the till the reasonable date.
The learned counsel for the petition also are district keyboard. The learned petition keep bringing
Hmm.
and application
Hmm.
second hybrid. Again, here is praying for washing of the criminal proceeding. And being CR number being registered as CR case number 5 shows 451 and standing before the court of GMFC number 1. Number where the cognizance has already been taken against the petition. Petitions. Issue notice to the respondents to their post as well process. No problem notices required to serve state. Further considering the submission made by the further proceeding in the same case with respect to the state.
Till the initial issue, till returnable date. I don't want a little longer.
3 weeks. Let the matter be accordingly listed up to 3 weeks. Okay, it will be stay till 3 weeks.
11.
See, can see it.
May I please your lord?
Yes.
Right, it's an application of 520 BNSS for quashing of the charge sheet matter. What happened, my lord, in 2019, 17, my lord, we got married, both the informant's daughter and myself. And their case was registered against me under 366 IPC, and case was charge sheeted. Subsequently, there was a registered marriage also. And my lord, when the notice was served, bailable warrant, my mother-in-law appeared, who lost the affair, that my daughter is living happily with her husband, and they got the marriage registered. We don't want to proceed with the matter. But the court below has not rejected our prayer. Now, my lord, I have come before your lordship that when they are married couple, my lord, whether they should be disturbed. There are judgments of the they're having 2 children. I have given 2 birth certificates also.
Why she is not a party here?
Beg your
She
pardon?
could have filed the petition as the co-petitioners here.
My lord, in the court below, my mother-in-law has filed an application. Who was the informant?
That's what I'm saying. Informant as well as the victim could have appeared before this court as the co-petitioners. Petition number 1, 2, and 3. Joint petition could have been filed.
My lord,
But here only
all
it
respect, my lord,
seems that only Sushant
because
Sarkar is the only
POXO is
one
not there.
Huh?
POXO case is not there. It is a regular 366.
POXO, not POXO. I'm not behind the POXO. I'm just saying they could have appeared as a petitioners also.
Yes.
Joint petition could have been filed.
Yes.
Anyway, what is the stage of the case at present?
No, my lord, non-bailable warrant has been issued against me.
Since 2019, madam, since.
2019 since.
But there are settled decision of the apex court.
It will come. I'm saying what is the stage of the case?
If your lordship,
After charge sheet, is there any evidence is not recorded?
no,
Because
in the
you were
court, my mother-in-law appeared and filed application.
Our evidence is recorded?
No, it has not yet started. Evidence has not started.
Paragraph 7 to 13, page 6 of the petition, madam. Pending since 2019.
Yes, it is pending because we are living happily. Husband and wife charge sheeted was done. We have made the appearance. My mother-in-law have filed application to the court that they should not be disturbed. They are married couple. They are blessed with 2 children.
Hard district. Series 1, Mr. Keyboard. It's an application, section 528, PNSS for washing and setting aside the being signature PS case number 519, in section 366 IPC as well as the charge sheet being numbered as 447 of the criminal, which is pending before court of learned CGM Kachar. Next. Notice to the sponsors formal notices, however, no formal notices. Further, next submitted by Mr. This was that during the after filing of the FIR, the both the petitioner and the victim got married, and thereafter on their marriage has been registered. At present, they are staying as a husband and wife and blessed with 2 children. Really, his partner proceeding expense state may be stated this that the further proceeding in PRC case number 444/2018 pending before the learned. Where is pending? It is pending before which
Before my lord,
CGM 366 will
yes,
there.
it is pending before the court of the Chief Judicial Magistrate, madam.
Why?
It is not yet committed. That is the matter. I have not appeared.
Committed.
I have not appeared. That is the problem.
Oh,
Since 2019, my lord.
since
Yes.
But my
2019.
mother-in-law has
And-
filed application where notice was served. That is I have annexed, my lord, before your lordship.
If it
that is a page number,
my lord, then matter would have been
page number
authorized.
47, my lord.
Whether my lord now she is living happily with the my lord present petitioner, that is a question mark.
My lord, it is the application of my mother-in-law 31/26, page 47. My mother-in-law has filed this application. She was the informant.
No, why she filed the petition?
If your lordship want that, I will bring the mother-in-law. I made her party also. Let she file an application before your lordship, madam. There are series of judgments of this nature, my lord, in the apex court.
PST listing also called the scan of the missing along with the PST.
And if your lordship want, personal appearance may be given both in this honorable court. I'll bring them.
But as per at present, apart from your verbal submission, there is no document that they are staying together, they got married, there's any compromise, nothing that short is there available in the
So yes, their mother has written. Mother application 47.
It
Kindly
forgets
see.
about mother-in-law, but there are other documents are not there.
Yes, their birth certificate, marriage certificate, my children birth certificate, page 50,
These are there.
51, 52.
We have stayed your proceeding till next date of listing, list accordingly after 4 weeks as on it. We are calling for the case record. Sim. Then we put swab. Who is like আপুনি কৈছিলে ইমান বা মোচন নিদিয়া হলে হল Yes, Mr. Gupta.
My lord, this is revision against conviction, my lord.
Huh?
This is revision against conviction, my lord. Petitioner is convicted under section 138 of the NI Act. And my lord sentenced to RI for 1 year and fine, my lord. Against that, my lord, appeal preferred, appeal also dismissed, my lord. So at this stage, I pray that a notice may be issued.
Mr. A.K. Learned Counsel. It's an application, section 4.8 BNSS, section 442 of the said code against the judgment and order dated 19/2026 by the Learned Session in Turkey in criminal appeal number 15, 3/2020, whereby the judgment and order dated 28/06/2024 passed by Learned CGM in Turkey in NI case number 113/2021 is upheld and bill was dismissed. Issue notice to the respond to speed post and usual process, and also call for this disseminate accordingly 4 weeks as on a date. You have an
I have for stay, my lord, suspension of the sentence.
Mr. A.K. Gupta, Learned Counsel for the petition. It's an application under Section 138, subsection 1 BNS for stay of the operation of impugn judgment and order dated 28/06/2024 passed by learned CGM Tinsukia in NI case number 113 of 2020, as well as for suspension of sentence passed therein and affirmed by the judgment dated 19/2/2026 passed by learned session judge Tinsukia in criminal appeal number 15 of the considering the submission made by learned that the operation of the judgment passed by the learned court, learned session judge, as well as the learned CGM in NI case number 1, the stay public suspended till disposal of the connected revision petition. And any other prayer? You are previous bail?
Yes, ma'am, till 27, ma'am.
27 of this month.
27 of this month. So
The previous bail granted earlier to the present petitioner be extended till the disposal of the next. Petitioner will accordingly remain on his previous bail till disposal of the connected criminal petition.
well, I am a bit
Reservation
disposed of.
I stands to
Obliged.
My lord, in this case, it was called for along with FSL report last occasion. The petitioners already in interim and recorded a statement lawsuit.
My lord,
they are
yes, 15, 16 and 7. This is a case, my lord, where one newborn baby, my lord, expired due to, my lord, breakdown of phototherapy, my lord, placed in the NICU at the Gauhati Medical College Hospital, my
yes.
lord. It's a old pending case, my lord. Case is pending since 2025, my lord. One petitioner number 15 is she is the nurse, my lord, and other 16 and 17, they are the doctors, my lord, who were on duty at that point of time, my lord, when the incident occurred, my lord. And my lord, regarding that, in the case diary, my lord, case diary CD is up to, my lord, although earlier there is a direction for updating the case diary, my lord, here, my lord, CD is up to 3/12/2025. All these accused persons are in interim, my lord.
We have already recorded a statement.
Their statement is available, but my lord, PM report, although my lord, regarding cause of death is not conclusive, my lord, FSL report is also not there, my lord. Otherwise, my lord, this case is pending, my lord. Earlier there is a direction for updating the case diary, but till now, my lord, FSL report not. Otherwise, these accused persons are all are in interim, my lord. They appear.
In BA also you are in
BA
also released on bail.
BA, my lord, she is the nurse, my lord, who was
In item 15 lordship, another counsel is there. She is the nurse lordship. I am in item 16 lordship. I am the first year student in the PG course of the pediatric department. And my senior counsel is for
Item 17, he was a PG doc student, but
both are PG student.
case is registered under section 105, my lord, culpable homicide amounting to murder, and section 3/5.
tragic incident that happened. Newborn baby died.
Yes, my otherwise there are, my lord, some, not only a case of mere negligence, but they are also, my lord, sometimes fail to, some materials is there against the, not because at that point of in that phototherapy plate only, my lord, that in that NIC only one baby can be kept. But my lord,
Yes, one
only
baby
4
cannot
babies
be.
were, my lord, kept there, and therefore thereafter breakdown of that phototherapy plate, my lord, this incident occurred. Otherwise, these accused persons, yes, they are, my lord, cases pending since long. All are in interim protection. Their statement is available in the city.
You are on 15.
I am in 16 lordship.
Otherwise, materials, my lord,
Who is on
affecting
15?
section 105 is there against them.
Pardon?
Materials, my lord, it can be said this is a case of, my lord, case is registered under section 105. So there are some materials that this is a case of, my lord, 105, because they are totally, my lord, not only case of mere negligence. There are other some materials is there at that point of time in a tray, my lord, and NIC only one baby can be kept. On there are total 4 babies were, my lord, kept in that tray, and because of breakdown of that tray, my lord, ultimately this incident occurred. Otherwise, my lord, case is pending since long, and they are already protected. So,
we got the interim order on 10/9/25. And we have cooperated, recorded our statement.
Yes.
And since then, we are enjoying the benefit of the payer's bail.
You are on 16.
Yes.
No, you
10,
were on
9,
17.
2025.
No, you are on 17.
I am 17, man. All are on same
You-
footing, mother. My friend is also doctor.
You got bail on?
Bail on 10, 9, 25.
And 16?
16, Lordship, I got the bail on 8, 9, 2025.
Their statement is
You
available.
are doctor.
No, I am not a doctor. I am a student, a PG student. We are not doctors.
PG
I am also PG student.
We are not doctors.
You are PG student.
Hey, that is MBBS we have passed, then we are starting the PG.
But they were on duty, my lord, at that point.
You were on duty, you are
Yes.
PG
But
student, you
there
don't
is
have
no
any
negligence on
sympathy,
our
you
part.
don't have any love
We have
for
done our
PGs.
best.
Huh?
We have tried to give all the
What kind of things you have done? You have what you have tried? What you have tried level best? What you have tried?
The delegation has been brought that our negligence, there was no negligence.
No, what we have tried our best means what you have tried?
But what is the
Keeping the
limited
poor babies
resources
in
in
a
the medical
tray,
college?
what you have tried?
And the child was kept in that way.
No. How you have tried your best? Save the babies or life
To
because
our
they
humble
were in
services,
that room.
we have there is no negligence on our part.
Then why you kept 3-4 babies in a tray?
That has
In
case
one
has been
tray?
registered against us. That's why we have come before us.
No, why you have kept? Why you have kept 4 babies in one tray?
There
You
was
are
no other
doctor, you should have
arrangement.
love
What to
for
do,
the
man?
babies, for the patient. You are the PG students. You should have humanity ground. You should have love for the babies, especially the babies, the newborn babies. For your negligence, they died. See? You are MS? S? 15 নম্বৰটো S নাজদিন আছে এইটো BA বিৱৰ্তকৰ বাকী লিখিব You were on interim bail since when? 8-9. It is submitted by her since 8-9. She is on interim bail and never jumped at the actions of the bail. Still ready and willing to cooperate the investigating officer in further investigation. As she was in custody, her statement has already been recorded during the investigation. Next, what would the learned petitioner be submitted that the petitioner statements are available in the case record, and the PM report is the cause of death could not be ascertained till date, as the FSL report is still awaited. Mr. Bottom participated that the case record, the CD is up. The last entry in the CD is on 3/12/2025. So the reminder was issued for publication of the case. It is however accepted that the case is pending since law, and the statement of the petitions are already available in the case record. So there are some implementing measures against the petition. Against submission so break. Next, during the submission with consequences, considering the materials in the case type, and also considering the fact that the petition is pending since law, and that will repeat for the the petitioner is hereby directed to appear before the investigating officer fortnightly or as and when required by the IO for a purpose investigation. CGM Kamro?
Yes, ma'am.
CGM Kamro. Our 2 number 10 for IAK4. They got the interim bail on 8/9/2020. And since then they are cooperating in the investigation of this case. However, petitioner however, the petitioner is not has not committed any such offense as alleged in the DSA, and he or she DSA. She is a PG student.
I'm first year student.
Huh?
Petition number 16 is a first year student of postgraduate.
You're a PG student?
I am also. I'm PG student of first year.
Oh, PG student. This for safe with the student 89 2025 they got no. 17 you got the on 10-9, na? He got the interim on 10-9 and after obtaining the interim had cooperated investigating officer, his statement is fully recorded. Court submission. Okay, matters have been disposed of.
Right.
Your interim paid kita go
No, they are not. Absolutely. Good voting. 90. Apply also.
Yes, 19.
Wait, please, Lordship.
Yes, 19 CD received here.
19, my lord, CD not received.
I'm 66 days. I'm behind the bar.
66 days.
66
What is
days.
the case about?
Your Lordship, it was registered under section 62-313. Your Lordship, basically the allegation, there is no,
Just I don't have time. In fact, what is the allegation?
yes, there is no specific FIR filed against us, Your Lordship. We are three petitioners. Police, on suspicion, there is some
Yes,
secret.
what is your submission? They are in 66 days behind
Yes,
the
Your
bar.
Lordship. And two opportunities already given to the prosecution side to produce the CD. It was submitted on last occasion that, that they will produce a CD. This occasion, Your Lordship, they have failed. And it is 66 days.
Sixty-two.
Yes.
61 is also there.
Yes, my lord, it was 90 days offense. My lord.
90 days.
This
Where
only
is the
for
FIR?
FIR. FIR is a pet page 12.
Very small handwriting. Do you have any other type copy?
Oh, yes. At page 15, Your Lordship.
No, this is the FIR.
This is the FIR.
So why you are showing 12, page 12?
It was the earlier FIR was Azahar was there. This is the 15, Your Lordship.
So
will
you
find
were
it.
booked under which FIR?
15, the same FIR, Your Lordship.
Same FIR.
The same FIR.
Why same FIR?
There is no specific FIR filed against me. It was the FIR was filed by the ASI of the same police station. It was outpost of the police station, and they received then secret information regarding it, some theft, and out of suspicion, we are booked. There nothing was recovered from our possession, Your Lordship. It was the only based on some information. No articles were recovered, nothing, and no specific allegation filed by any person, Your Lordship.
Yes, what?
Yes, my lord. Initially, my lord, one Sonu Gwala was arrested. This is a gang of my lord burglars, my lord, and thereafter, on the basis of his, some items for housebreaking were recovered from them, my lord, and thereafter, on the basis of their statement, some other accused persons were also, my lord, apprehended. And there is also, my lord, furthermore, it has come to light that all the stolen gold jewelry is disposed of to a person, namely, my lord, one Pavan of Moran Hat, my lord. So only
The Sonu Gwala, which was arrested, and
recovery, regarding the recovery, what do you is there? Is there any recovery?
No.
From Sonu Gwala, my lord, some of the item from his possession we recovered housebreaking tools, including an iron rod, lever, iron crowbar, sabul, screwdriver, and pillars. All these things were recovered.
Regarding this, I have a submission, Your
From
Lordship.
one Sonu Gwala.
Yes, I'm not for Sonu Gwala, Your Lordship.
These petitioners are how there is the forwarding report is at page?
Forwarding report, my lord. Forwarding report. Okay. Page 17, my lord. The accused persons are members of an organized criminal gang.
There are nothing, any materials to prove that we are a member of the gang, Your Lordship. So far.
From those grounds of arrest, he is the member of that gang, my lord.
the tools that the police they have indicated that they are housebreaking tools. They are the regular items. And in respect of petition number 2, he is a worker of North Frontier Railway, Your Lordship. He
There are three petitioners.
three petitioner, Lordship. From the other two petitioners, there were nothing were recovered. And these are the only household items which were recovered, and it was not from inside the house. It was from the outside of the boundary.
Apart from those items, this
There is-
screwdriver, sabul, etc., is there any
They are
recovery?
the
No.
ordinary items.
Only because Malad, they are the members of that gang. Initially, that Sanugwala arrested thereafter, Malad.
Otherwise, Your Lordship, our investigation has already been done. There's nothing left. Witnesses are already been, their statement has been taken so far as my information. And further custodial detention is not required, Lordship.
But you are Mr.
PJ Das.
Are Mr. PJ Das, also for the petition, Mr. Keyboard, sitting. Submitted the intimation that received. Yeah. This is the next practice in application section. 483 PNSF for grant of paid with next events. This is submitted by Mr. Das in unanswerable petitioner that these petitioners are arrested only on suspicion and there are no way connected to the arrest office. Nothing has been recovered from their position except some household items from one of the co-accused, Sonugwala. But from these three petitioners, there is no recovery to that regard. However, the petitioners are in custody since last 66 days, and hence, considering his period of detention, they may be released. All the petitioners are ready and willing to extend their cooperation in the further investigation of this case if they are granted with the privilege. Next, para Mr. Botako, the learned additional PP submitted in this report that the SCD is not available, he is not in a position to submit more about the merits of the case. From the forwarding report and the other methods in the record, it is seen that initially one Sonugwala was, and thereafter the other three accused persons, these three petitioners were also arrested in connection with this case, who were stated to be a gang of the burglary operating. He was stated to be members of the burglary gang who is operating, who is committing such crime in the local area. Further, some of the items like screwdriver, sabul, etc., were also recovered from the person of the co-accused. So, Mr. Waterford accordingly submitted that further of the case there will be required to know the involvement of the present petitioners in the arrest office. Next, hearing the submission made by the all other aspects of the case vis-a-vis the period of detention already undertaken by the petition. I find that sufficient opportunity. There was sufficient opportunity for the IO to interrogate the accused petitioners, keeping in custody, and hence, court is of opinion that further custodial interrogation may not be required. It is to be whose satisfaction?
SDJM Titapur. Now it is on. It is with the JMFC Titapur.
SDJM Titapur. How many bail matters? Please. Mr. Botapur, there are many bail matters are there, but from two we have the part third matter.
Yes.
I don't know how many items. If the items may not reach also. In how many items you have reached you received the case diary?
5 mil, till 5 CDs.
5 items. Means, huh?
25 items.
Item number 25 CD is there?
The CD is there, ma'am, regarding.
Item number 25. It is AB. Are you on interim there?
Interim is there. I have complied when I have given this.
No, whatever. We may not have time to pass the order. That's why I'm just.
But
You are on interim?
Yes, madam.
CD received, na?
CD
When it can be retained?
Yes, your lordship may fix any, say.
To skip and the matter to be heard. CD received. Written the case diary till next date of listing. List the matter accordingly.
Do you mind?
CD to retain for good.
Second or 5th of March or 2nd of
5th of March, no. Maybe on 2nd of March.
2nd of March.
Yes.
CD be retained till next date of listing and interim be continued till next date.
Lordship is taking the regular bill, my lord.
No, I'm not. We are not taking. Just asking from whom this case is facing because we not have time to record your evidence because at 2 I have the partner matter. So that's why I'm just asking the what are the matters.
Then my item number 21 and 22, my lord.
21 and
21 and 22, my lord.
what is the position of 21 and 22?
21 CD received, ma'am.
It's a 60 days offense, my lord. We are behind the bar for 43 days. Can it be day after tomorrow then?
After tomorrow may not be possible because
If it goes to Monday, near about 50 days.
Monday it will be 50 days.
Yeah, today is 43, my lord.
Almost.
If I will try, my lord, if possible on Friday, my lord, we'll take a chance.
Friday, no, for Friday morning. Maybe on Thursday. Thursday.
Thursday to calculate.
Possible. Monday at least may not be possible.
21 and 20.
But 23 also similar prayer, my lord. 23 also yet behind the bar.
Just a second. 23 also CD
CD
received
received.
here.
Yes.
21, 22, 23. Otherwise, we're listing all the matters on 2nd of March. 2nd of March.
23, my lord, Monday.
This 2nd of March. Yes.
23.
Yes, 23 also.
2nd of March is Monday.
Monday is 2nd of March.
Oblige your lordship.
But one thing, I just don't know if any reasons if the matter is adjourned, then it may be hard also. But anyway, possibility is less because we will hear the matter or the part-heard matter. So we are listing it on 2nd of March.
Lordship.
CD will be retained till next date of listing.
I'm deeply
So
obliged,
CD
ma'am.
be retained.
I'm obliged, man.
All right, item number 26. Police report was called for and there is an interim order.
26, whether we have received the case diary here? 26?
No, my lord.
Report was called
Did
for.
we not receive?
My one report was called for, my lord. Report received, my lord. There is no case taken.
No case. No case against you. Okay, we can pass the order.
There are 5 petitioners here, my lord. Report is only in respect of Anup Purva. So I will have to again get it because only against Anup Purva there is no case till date. But there are 5 petitions.
You are 5 petitions.
5 petitions.
Although the report is stated to be received for stated to be this the report is stated to be received against only one. What is his name?
Anup Borua.
Anup Borua, but there is no mention about the.
Again, here is no case has been found registered directly against the Anup Purva till date. There are 5 petitioners, but what directly against the Anup Purva till date.
Though report is submitted by the IO, but the report is not seems to be it is not clarified as to whether any case has been registered against the petition. In view of this, let a fresh report be called for from the concerned IO. List
There is an interim order.
when it can be listed. 11th, 5th, not 5th. 11 or 12?
On my lord, 17th of March.
17.
Interim
17th
order
of
passed out
March.
when
So and so.
continued process.
Interim be continued till next date of. You were on tape. And
Interim, no coercive measures already.
yes, interim will be continued.
Lordship, item 28 and 29.
Then item 28 and 29, we have received the case diary here.
28 and 29 my lord, case diary not received.
Are you on interim? No.
No, Lordship. I'm not.
You are not on interim.
No. But Lordship, I want to say one thing, Lordship. The allegation.
No, we're not going to hear the matter.
Okay.
Just
No,
asking.
not on interim, Lordship.
Not on interim, na? 28 or 29, same order was city not received. Issue reminder. They are not on interim when it can be listed.
12 of March.
12th of March will do.
But it will be too far.
Long.
Little early, man.
9th of March.
Fifth.
5th, we cannot post it on 5th. There are many matters on 5th. 6th pariboniki. At best on 6 can be.
6.
You can try, but I don't know because 3, 4, these are all holidays. That's why probability of receiving the case there is very less on 6th. Let it be on 9th itself. It will be me. 9th. Order my 9th. Yes, what about 30?
Lordship.
Yeah,
30. You are on 30?
no, 24 Lord.
Just a second. 30, who is 30?
30.
30. Item number 30.
Item number 34. 31
You are 30. You are on
report
interim.
was called for, report not yet received.
Are you on interim?
No,
You are not on interim. CD received here?
no, my lord, no case registered, well, only a report was called for, report not yet.
Oh, yeah, no case is registered against you.
No, my lord, that report not yet
was called
received.
Oh, not yet received.
Not yet.
Achha. Report not yet received. Issue reminder. The learned petition PP will take necessary steps. List the matter accordingly. Let it be on 6th of March.
Yes.
6th. Because you are not interim, we are fixing it on 6th. 31, is there anyone? For 31? What is the position of 31?
31, my lord. One case registered, what my lord, PD not, whether any case registered or not, my lord, that report was called for, report received, case registered, my lord. So, your lordship may call for the case diary, my lord.
Okay, then we'll pass the order at 2. Yeah. And we'll receive a listing at 2. We have to order has to be passed. Huh? Then you are on 24.
Yes, lord.
Yes. What is about 24?
24, my lord, case diary received.
Case they receive. You are on.
Lordship,
You are behind the bar since when?
yeah, 25, 25-1,
25/1. Near about 1 month.
1 month. Lordship,
Under which section? Case is registered under which section?
yes, 305, some cows are stolen. The allegation.
Stolen cows are there.
Lordship,
CD
all the
received.
requests are already released.
Huh?
This honorable also released the main request, and the honorable district court
Okay, then
also
we
the
can,
other.
retain the case diary. We're not passing any order. Can retain the case diary till
But next week, Friday.
This week is not possible.
2.
9 will be too late for him.
On then 5th or 2nd.
5th or
Second.
2nd of March. Yes. CDP retain till next set of listing.
Obliged.
We're listing the retaining the case diary.
May I please? Lordship, I am for 27, my lord.
27.
7.
Yes, 27. What is the position of 27? You are on interim or not?
No.
Not. You are not on interim. Then can it be fixed at 2 p.m. here? I don't know the matter. If runs, then we pay. I don't know what will happen. Anyway, let it be on 2 p.m. because we have to hear the matter.
Because of the FSL report, here one.
Not yet? But on the basis of the other evidences, we
My lord, but
able to say something, then it can be.
my lord,
fixed.
FSL report is here required, my lord. Here it is the
No, we are not going to hear. Just tell us. FSL report will be required.
required. CDB written, my lord, we will call for the FSL report.
Some
Not that
report.
man.
Okay, it will do then. CD, we were going to retain the case.
Not
diary.
that man.
No,
Huh?
no, how it is not that one? It will have to
No
come.
template is here.
Right.
CD we retain. Direct an additional PP will call for the your PM report is available.
Available. FSL is
And
Malad
recent
here.
report from the IO concern. IO concern. CTB written.
Chemical examination for RFS.
List. Huh? From
Regional forensics and laboratory Malad, that is report. Yet to come.
when it can be listed. In that case, if you are going to retain the case diary.
Malad.
Maybe on 6th or March.
Malad 9th Malad 9th.
9th.
Blood.
9th. Is there anything is left? 2020. 20 is there. Your scan copy was there, na?
Yes, Lordship. Lordship, it will take some time also, Lordship. So, Lordship may kindly fix it on the 2nd or 6th.
Yes, when it can be fixed, 2nd or 6th.
My learned friend is will.
Malad, I have already gone through.
He has already gone
You have
through.
already
I'm
gone through.
on 2nd.
Anyway, 2nd.
On 2nd.
As per convenience of the court.
If it is otherwise possible.
On 6, it may be 6 Malad.
Maybe on 6th then.
Yes, not 5th.
Because 2nd.
No,
matters
5th
have
several
been-
matters are there.
Several
in
matters
the earlier
on
court.
6th of March. We're listing it on 6th of
Minor.
March.
6th.
Please, Your
And
Lordship.
admission matters are there. May not be possible to hear the matters, but if time permits, then we try. But at this stage, I cannot say.
Can I
Because at 2 p.m. We are listing it.
Lordship, can I clear that item 14 admission matter, fresh admission be taken up on the day after tomorrow?
31. Just for 5-10 minutes. One matter was there, 31. I mean, it was fixed at 2.
Oh,
Just
yes.
for 10 minutes. 31. Full.
31, in this case, there was case registered.
Case already registered.
Yeah.
So whether the no, this in that case, interim protection was provided to him, na?
Yes, ma'am.
Interim protection was provided to him.
PB may be called for. Poco PS case number 50 of the 2026.
Poco PS case number
50, 50.
31, 31.
50
Certain I am appearing, Lordship.
50 oblique
2020.
26. Against you, the case has already been registered.
Lordship, but my humble prayer before your Lordship, just I want to know when the case is registered, actual date, and when the JD entry was met.
Okay, my lord,
That everything will reveal if we call for the case diary only. Only report we have received.
I think, Lordship, in report, Lordship, date also be mentioned, I think.
Yes, is there any date?
Date, yes, report, date of the report is 21 to 2020.
21.
To 2020.
But Lordship, as per my instruction, Lordship, the police officer, the IO also went to the house of the petitioners, 9 as well as 13 also, Lordship. And Lordship, we have lost the complaint against the
No,
IO, Lordship.
these are not the question is that your police officer visited to your place. For
Yes.
that reason, there is an apprehension of arrest. So you approach the court with an anticipatory
Yes, Lordship.
application. Now we call for the report. It has reported that case has already been registered against you.
Yes, Lordship.
So now, if you want to know all these things, we'll let your case diary will reveal everything.
Yes, Lordship. But my humble submission prayer is, your Lordship. But GD entry also met after submission of the complaint, Lordship. After file of the
Look out.
The schedule.
Your complaint may not register. That is not our lookout. But your petty case
But
has been registered
in the
against
meantime,
you.
some protection may be given,
You were
Lordship.
protected, I think.
Yes, Lordship.
Was there any? Oh, protection was not there, na?
Humble prayer, Lordship, some protection may be given.
You're calling for a case diary. Heart, Mr. You are Mr.
A Alim Sheikh, Lordship.
Alim Sheikh.
A Alim Sheikh.
heard Mr. A. Alim Sheikh, the learned counsel for the petitioner. Also heard Mr. B. Waterford, the learned additional PP, appearing on behalf of state respondent. It is submitted by Mr. Waterford that the report has already been received, wherefrom it is seen that the case has already registered against the present petitioner under Boko police station, being the case number as Boko PS case number 50 of 2026. Under section is there?
Yes.
Under section?
Now section 77, 78 2, 64 1, 62, 351 3.
60, no, 77, 78, 2, 64, 1, 62 and
351 in bracket 3.
351, 3.
And 3, 35, the 3,
35.
Of PN.
77, 78, 2, 64, 1, 62, 351, 3, and 5, 3 and 5, BNS. Read with section 67.
67A of the IT.
67A IT Act. In view of this, CDP called for from the concerned police station. Let the matter be immediate calling will reveal nothing, I think, because it just it is registered only on 21/2.
This report is on 21/2, but when case was raised, yes, on 21/3.
It is very initial stage, I think. When it can be listed.
GD entry was on 21/2.
And case also registered after that, Lordship.
Initially one Sontoli, OPCD number 292 dated 21/2/2026. And thereafter, my lord, probably this case.
So anyway, it is very recent, very initial stage. When it can be called for case diary? 9.
In the meantime, Lordship, some protection.
11th of March.
Lordship, some protection, Lordship. Petitioner will appear before the IO also, Lordship, and
No coercive action shall be taken against the present petitioner till receipt of the case diary based on 11/3. No coercive action.
For hearing,
Last two. Best. Yes.
Yes,
You are
but
going to reply on that.
I'll just give a reply. I'll not go beyond what is reply. Last of all, what I'll try, because we are basically, your lordship has to look into the injunction. We are not into the main suit, because your lordship is confined to injunction.
Yes, only on
Only injunction application and the order that has been passed by the learned trial court. Your lordship is examining that only. I'll try to, because I'll just give a reply to what they have stated, my lord, in 2-3 days. I was not present, my learned friend has noted down, and according to that, my lord, I'll give a reply. Quick reply I'll give, my lord. First, my lord, what they said is that this appeal which has been filed is bad because non-joinder of Pradeep Das and performer defendant of this in this suit. I think this is what my learned friend has noted. To this, I'll give a reply that it is not necessary that Pradeep Kumar Das or performer defendant has to be made in this, has to made a party in the FAO. Why? Because, my lord, they have filed the injunction application. In the injunction application, if your lordship looks into it, my lord will kindly see that Pradeep Kumar Das was not made a party by them. Neither performer defendant was not made a party in the injunction application. So, not necessarily that I will make in a FAO
Pradeep Kumar Das and other performing defendant in a FOA application. Because I am challenging the injunction order that has been passed arising out of that injunction application. This is my first answer, my lord. Second, my lord, they said Pradeep Kumar Das' written statement is not annexed along with the appeal. I think that's not correct. Please mark page 92, 99 to 110. This we have annexed the written statement of Pradeep Kumar Das. Page 99 to 110. Your Lordship need not have to go through it. Please go afterwards, my lord, whether my statement is correct or not. Third, my lord, which is most important. My lord, when we argue before the court, it should be restricted to the pleadings and the statement that has been made either in the plaint if you annex or in the written statement, whatever it is before this court. We cannot something on the air, whatever we like, or my lord, we cannot bring certain suit before the court. I have been told that they have brought a suit, title suit 130 of 2018. They cannot bring that suit which is not on record. And that suit I will explain later on, my lord. That suit is between our family members. They have nothing to do with Sarita Devi Jain. And I am giving a reply to this. What they said, that third point, that genealogy as described in the plaint is disputed. The genealogy which we have given is disputed and relied upon written statement filed by Vandana Medi in title suit number 130 of 2018, now which is not a part of record, nor annexed by respondent in this suit. My lord, why we will annex that suit, which is not a part of the proceeding, which is not required. I'll put in this way, it is not required to bring notice to the court about title suit 130 of 2018. It is between my family, it is a family dispute between my lord Birabhadra Medi and Vandana Medi. What is there to do with this particular suit? Now, in that suit, the dispute has been made about genealogy. What is there to bring? How my genealogy, Sarita Devi Jain will know my genealogy? They are a third party. How they will know? They cannot know my genealogy, my lord. So now my answer will be, my lord, in this suit, it is admitted that the suit land belonged to Subhadra Medi, who died issueless. My lord, that is a fact. They cannot change that. If now the problem is that, my lord, they are disputing that this Kaliram Medi had 3 wives. I have been told that was argued before the court that 3 wives. From where they got these 3 wives? From where? From the title suit 130 of 2018, which was passed over this way to the court. My humble request that your lordship will not take into account which is not a part of record. I can give 100 of papers to the court, but why the court will accept those papers which is not connected with the case? So my submission before this court, it is a fact that Subhadra Medi died, my lord, did not have any issue. No legal heirs. It is not being disputed. And what they want to say, my lord, if they dispute about genealogy that Kaliram Medi had other legal heirs, and they are trying that Subhadra Medi does not have exclusive title, that means what they are saying, if they have 3 wives, then your title of the property which was bestowed to you by Pradeep Das, we have a doubt on that also. If they have 3 wives and they are doubting about the legal heirs, so your particular title also is to be doubted. So I am not going into that aspect of the matter. That will be decided at the merit of the suit in the trial court. I will not trouble this court. I am saying that they should not have troubled the court with 130 of 2018. My lord, it should be straightforward the case. This is our case. Maybe I'll tell your lordship, if I find that I have a weak point, I will tell before this court, this is my weak point. But why I'll try to bring notice to the court about which is not relevant in this case? This is what they are trying about, to dispute the genealogy of Kaliram Medi. This is, your lordship will not look into the aspect of the matter. This is the trial court will look at the time of deciding the suit. This is my third answer to this. They put their argument before this court. This is my third answer. Now, much has been now fourth, my lord, point. Much has been said about, they argued in favor of Bandhana Medi. They argued many things in favor of Bandhana Medi. Now, why they are concerned so much of Bandhana Medi? If they were so concerned about the Bandhana Medi, my lord, please see that while in mutation, because her as a co-patadar, her name was recorded. Because Kaliram Medi as free or as a co-patadar, her name was recorded. Now, when your lordship knows, when your name appears as co-patadar and when mutation is decided, definitely a notice has to go. They did not wait. They did not wait also for the notice, to give notice to Bandhana Medi, my lord. They have striked off, and which was not served. And they said this was not served due to non-finding of proper address. And your lordship will kindly mark this, your lordship will see at page 50. Your lordship will find at page 50. I will not read this, my lord. I don't want to read. I'll try to make it as short as possible, my lord. Only please mark, this is their argument which was made.
50.
Page 50, 50. It was striked off. She was a co-patadar. If you are making so favor in favor of Bandhana Medi, then you could have served notice, and you said that your notice could not be served due to non-finding of proper address, and it was strike off. You could not have done it. Now this is fourth. Fifth, my lord, which is most important. What they said, non-furnishing of certified copy of police document. Because your lordship knows, recollect, we said about argument before this court that all the sale deed was a fake sale deed. Now I'll tell your lordship, makes it very clear. This deed has to be decided by a trial court. Now whether it is a forged or whether it is not a forged, it will be decided, because we have challenged both the sale deed of Pradeep Das as well as Sarita Devi, followed by their mutation. I will not trouble this court saying that your lordship has to decide. Why we brought notice to the court? I am putting a question and making an answer to it. Now, I'll give a reply. They said that no certified copy. Just I am arguing before the court without any certified copy of those police documents. Because I brought notice to the court. I made an FIR before the Bhorolim police station. They said a lot of things about Bhorolim police station. They said a lot of things which I don't want to say. They said something which is not permissible. They said pet dogs. In fact, this should not have been spelled out in the court. We are the pet dogs. We are throwing them and they are like a pet dogs. My lord, whenever you say, you have to be very careful what you are saying for the court. So this is important, my lord. Whatever you like, you can't say in the court. Now, this is not correct. All documents are certified copy. My lord, please mark this. From page 189, please mark 189, 194, 214 and 219. Their contention itself is not correct. They said that these are not certified copy of police document. How you are arguing a matter? Like they are saying it's a piece of paper you brought and you are arguing the matter. We will not argue a matter without looking the briefs. And I am proud that all my juniors have briefed me properly. I am only a senior, my lord, but they have briefed me properly. And something wrong is being done, I will take all my burden to me as a senior counsel. So I will say with great respect, I will say that these all are certified copy of documents. Now, if for a moment I'll just trouble with your lordship at page 214, please 219. See 219. Now they are saying that we got directly from DCP. 219.
Yes.
They have brought. So my lord, this they are trying to project before the court that we are relying something which is not a certified copy and relying before the court. All I just, your lordship has noted down. Please look into 189, 194, 214, 219. I don't want to show each and every document. This will take 2 days again to argue the matter. I don't want. I want to finish it off as fast as possible, my. There are other few matters also before this court. Now this is and all throughout they argued that it is an hand in glove with the police. This is what I have been told, that all they acted in connivance with Bharolimuk police station. That's their argument, precise argument. My lord, I'll give a reply to it. It is not absolutely incorrect. My lord, why? This has been only for the purpose. Your lordship knows, recollect the background of this case. What has happened? What led to file an FIR? My lord, the part of the police is only to investigate the matter. But the police is not there to cancel the sale deed. Deputy Commissioner can also, mutation can be cancelled. Revenue Court can cancel it. Now, if I am unhappy with the cancel of mutation, there is a forum which I can go DC or thereafter to Board of Revenue. But the sale deed cannot be cancelled. Sale deed has to be cancelled through an appropriate court, that is the civil court. Your lordship knows it, my lord. So the investigation, the mode and manner in which the investigation has been carried out by the Bharolimuk police. Now what they are saying that all the time through they are saying Bharolimuk police station, Bharolimuk police station. This Bharolimuk police station, please look into it. It has been handed to a crime branch. Crime branch will investigate the matter. Now today, from the crime branch, it has gone to CID. All this has not been stated before the court. Please see, my lord. I will not show something which is not relevant. I will show something which is relevant in this case. Now, please see. I had a copy. Please give him a copy. Criminal petition. They moved. 510 of 2025. Please look into it. It is, they have gone before the court for quashing of the investigation, my lord. Now, please see. See the third paragraph. Learned additional PPR received written instruction that the Bharolimuk PS case has been transferred to CID Assam Police, hence called for the status report from the CID Assam Police Station. These they have not shown before this court. So they are saying all the time, my lord, they are our pet dogs, and they are doing it. They are all in connivance, hand in gloves. But it is fact that it was looked after by crime branch. Lordship will kindly see, which I have annexed in the FAO, and thereafter it is transferred to CID. And this order speaks of, because the order said status report to be called for from the CID. And all the arrests was made through crime branch, my lord. Take this copy. Just keep it because I will. So this is, my lord, my answer. And the crime branch, my lord, your lordship will kindly took note, my lord, of the mode and manner in which the sale deed was registered and the mutation order was granted. Because, my lord, there has to be investigation, it has to be said. It is a fact, my lord, the criminal investigation can go simultaneously. And the civil court can go simultaneously. Now, crime did not mention about the forgery, the mode and manner in which my lord sale deed was executed. My lord, kindly see, in this case, my lord, I could have very well understood that Sarita Devi's son was arrested. But here the officials were arrested. This circle officer were arrested in this case. What more, my lord? Lord Mondal was arrested. Sub-Registrar Office, my lord, was put to question and they were arrested, my lord. The officials. Your lordship has looked into it and seen the report. I am not saying that your lordship, on the basis of that, your lordship will decide this case. Saying the mode and manner in which it was done, my lord. So because I have to give a reply, that's why I'm giving a reply to their argument which was advanced, my lord. Otherwise, I would not have given any reply to this, my lord. Now, very interesting, my lord. Your lordship will see the original sale deed, that is 2008, my lord, that has been lost by Pradeep Kumar Das. Original sale deed. And it is published the same in newspaper, my lord, and annexed the same as list of documents issued by the respondent, my lord. They have annexed, my lord, this a part of record. And please see, here I say, my lord will kindly see. Kindly see, my lord. Here I say, Joa Omuk Omuk Tarike Mur Nimlito, your lordship got Noti Homu, here I say, Jomi Besa Kina Mulo Dal Dolil number, A Dolil, my lord, same. A so and so logot Ono Sorkari Noti Potro, Potoloy, T Pradeep Kumar Das, so and so, so and so. So this list of documents was given by Sarita Devi itself. That's why I am showing, my lord. Now, my lord will kindly see. And what they argued, my lord, they have not submitted, search sheet has not been submitted. But they want to say, look here, all these are got up story. You had a connivance with and you made all this a story out of it. Till today, search sheet has not been submitted. What is going on? What is really going on? Nothing has been done. Investigation is done, all arrested, but today's search sheet has not been submitted. But I'll tell your lordship that they have challenged the FIR. I think your lordship is aware of it. They have challenged the FIR before this court. Court did not stay the investigation. What the court passed the order? Court said no coercive measure should be taken. That's all. But investigation has not been stayed by the court. And I know why, because I am appearing for the other side, being an informant in this case, my lord. Kindly see the order that has been passed by this court. See the order, my lord. And they stated somewhere, I will show, my lord. I'll show. Your lordship will just connect this with the order passed by the learned trial court. While injunction, my order was passed, they have stated in page 429, because it will be easier to connect, my lord. 429. If you see 429, I will just show that, my lord, so that it becomes more easier to decode. See 429, my lord. See, my lord, what they have stated. 429. Take 429, paragraph 7. Lordship got it? Paragraph 7. 429 of the injunction order.
Yes.
I have heard both the sides at length. During the course of argument, learned counsel petitioner defense number 2 vehemently argued that plaintiff for trying to take the benefit of their own wrong interfered with the possession of defense number 2 after getting her son arrested in a false criminal case, which is stated by the Honorable High Court in criminal petition 510 of 2000. How, my lord, these are, my lord, things I think we should not stay, because the learned trial court also is not aware of it. Learned trial court has got the impression, oh, this has been stayed. So, what is the impression of learned court? Oh, these has been stayed. So all these were false. That's why prima facie court, the High Court was satisfied. That's why it said the investigation. And that was what my lord, you kindly see, paragraph 7 says, because that was a submission made by the, and other hand, they are saying, we suppressed all material fact before the court. All the time we are suppressing material fact. This is who has suppressed the material fact before the learned trial court. Under learned trial court, my lord is not aware. Learned trial court was under the impression that yes, it has been stayed. And your lordship has said this is the order which has not been stayed. No coercive measure should be taken. That's only the order has been passed. Because only because the court has a sympathy, my lord will see, because of the age factor. Lordship has seen the order because of the age factor. Now, this is what, my lord, of this point number 6. And this is my answer to it. They said, for all throughout we acted in connivance. This is my reply, my lord. Now, point number 7, my lord. They said that all actions and civil consequences have been nullified. I think that's what they argued before the court. Now, to that point, I'll say that it is wholly incorrect. My lord, yes, what has been set aside by the High Court is, my lord, the mutation order. The mutation order has been cancelled by the Deputy Commissioner. When it was cancelled, my lord, they put to challenge before this High Court. And the High Court was right. I'll say the High Court was right because High Court said, you can't do it. It is amounting to violation of principle of natural justice. How can you cancel ex parte? You cannot cancel ex parte. So that order was set aside because it was an ex parte order. So it was set aside because it amounts to violation of principle of natural justice and sent back to again to the Court of Deputy Commissioner, notice to be served, my lord, to the parties. And according to that, my instruction is that it is now pending before the Deputy Commissioner Court. So it is not a case that they want to project the all action nullified. All actions, civil consequences have been nullified. Their building permission, my lord, all it has been cancelled. Whatever they have applied for, that has been cancelled. That has not been restored. If they can show before the court it has been restored, that's a different thing altogether. Their building permission also, I have shown, my lord, that building permission has also been cancelled. Only here the cancellation is the mutation order. It has been cancelled. Because it's absolutely is incorrect. Today I'll submit that is not correct in the ex parte order. So this is my lord, answer to their, my lord, reply in point number 7, my lord. Now point number 8. Now we file the amendment, my lord, without challenging the relief of confirmation of possession, which confirmation of possession, because your lordship recollect 14/8/2024, there was an injunction application which we have filed also, an amendment application which we have filed. And there we sought for confirmation of possession and also recovery and other reliefs. All has been allowed, but confirmation of possession was not allowed. What they want to say, meaning thereby that I cannot remain in the. If you are in possession, where is the question of confirmation of possession? Implied that you are not in possession. Answer to is this, my lord. The court examined the matter regarding our amendment. Court said, yes, we are rejecting your prayer for confirmation of possession. Only on the ground that you came into possession during the pendency of the suit. And we don't want to discuss who is in actual possession or the amendment petition filed by this response seeking recovery of possession. Now, my lord, they said, my lord, the FIR, this is point number 9. The FIR which we have lodged on 8/11/2025. Right? And the injunction order of the trial court was passed on 6/11/2025. ठीक है सर, date correct? Oh, they said about the earlier FIR which has been lodged earlier to that. And they said in the FIR which we have lodged, my lord, before the earlier FIR which was lodged that led to arrest and everything, my lord. Then they said that we have only mentioned about the probate title suit number 5 of 2018. We did not mention about the suit. We did not mention about the suit which we are pending. Now I'll give a reply to it, my lord. My lord, if the Horolimuk police station they investigated the matter on the FIR which has been, my lord, which has been filed by us. Now, to what extent the mode and manner in which the sale deed was executed, or to investigate the matter, found that there are a lot of people were involved in this case. The mode and manner in which the sale deed was executed. To that extent, not necessary, my lord, I'll mention about the suit and all those things, because investigation can be carried out separately, my lord. If I could have understood that no, they said that no, this sale deed is cancelled. They have not done it. If they also know the appropriate court and remedy will be a civil court who can decide the issue. But no one can stop them for investigating matter when an FIR is being filed. The mode and manner in which the sale deed was executed, how many people were arrested, my lord, in this case, they have done it. They can't say, my lord, that non-mentioning of the suit, it amount to suppression of material fact. They want to say that the IO, the investigating agency would not have proceeded with the case. That's what they are trying to say, my lord. Now, and what they said, that we suppressed in point number 9 itself about mid-J case number 71 of 2017, which, my lord, injunction was refused, which I read, my lord, that on the first opening, one is proceeding under 145, then I read that a probate has been filed. Along with that, we file about an injunction application. Not necessary. I have mentioned about probate title suit about 05 of 2018. Whenever we mention about the suit, it inclusive of the miscase of 71 of 2017. I don't have to mention that a miscase has been filed. I said a probate title suit is pending before the court below. And this, in the meantime, this has happened. That is how a sale deed was executed. All this has happened. Fake sale deed without permission of deputy commissioner, how it has been done. So they have investigated the matter. It doesn't mean the suppression of material fact, because mid-J case of 71 of 2017 has not been annexed in the FIR. So this is my lord, the answer to point number 9, my lord. Now point number 10. I think this is a very ridiculous type what they said. They said, my lord, this is an FAO and we file an application under Order 41 Rule 5. What they said, that there is no stay. Order 41 Rule 5, there is no stay. So it is only an FAO, an order has been passed. FAO, this order status quo as on today's element in FAO. So there is no question of the court granting now Order 41 Rule 5 was stay. This is, I don't understand. Sometimes we move a matter before this court. In a main case, only a stay is granted. Earlier, I remember very well, my lord, in some of the cases, the miscase has to be also moved, and there is a separate order in miscase. Now your lordship is seen, but there are a lot of high courts. In our writ petition is being moved, and a prayer is made in writ petition itself, and an order is being passed by this court. But if you go, my lord, your lordship had experience, in some of the outlying benches, you have to file a separate miscase also. Separate miscase to, my lord, for interim or relief. But in this case, an FO has been filed, and in the FO, the matter has been heard, because the FO has to be heard. So in my FO, the injunction application was annexed, the order was annexed, the court hears the matter, and ultimately this order was passed. So where is the question that they said no order can be passed, only it can be passed in the application under order 4105. I think this is incorrect. There is a illogical something thinking. So this is my, my lord, the 10 points, which in very short, I have given a reply, my lord, about 20-25
What
minutes.
about the other injunction?
Now I'll go to that, my lord. This is the main, because your lordship, what I am saying, lot of facts have been said, lot of facts. We have also narrated to link the particular case in what manner. My lord, what is most important is your lordship will note down the list of dates. 3 list of dates, 4, in fact, 1, 2, 3, 4. 4 list of dates is very important to connect the injunction. My lord, your lordship is testing the order of the learned trial court regarding about granting of the injunction. Injunction is always granted by way of an application that has been filed. It is not a writ court. Your lordship has got a lot of experience. We started our practice in a trial court. One will confine to the pleading. That's why we have been taught that whenever in a suit, you win and lose in your chamber, not in the court. If there is no pleading, you will not get any relief in the court. And my lord, your lordship knows how without pleading and some order can be passed by any court. Writ court, my lord, 226 is a very plenary in nature. It is more than Article 32. So it has got wide power. You have a power to mold the prayer also. But in a suit, there is no question of molding the molding. My lord, we file an amendment application to amend the plan. Writ court has got a wide power. So when a trial court judge sits in a court, one has to go only by way of a pleading what has been mentioned in the injunction and what is the main prayer in the suit. Now, in this case, first date is so important, my lord. It is 4/6/2024. Your lordship will kindly only see don't open the my lord file, only the page of 4/6/2024. What is that 4/6/2024? This is so important, my lord, to connect the entire order of the learned trial court. 4/6/2024 is an amendment application which they have filed. That is the date of 4/6/2024. Now, my lord, before that, my lord, 4/6/2024. Page no, page 231, my lord. This 4/6/2024. Right. Okay. Lordship got it?
Yes.
4/6 is Iman? 231. See 231, my lord. Please see 231. My lord, why I am harping this application? Because the order I will show in what manner the order was passed without making a prayer. And whether the learned trial court could have passed that order. See at 231. That's the crust of the whole matter, my lord. I'll have summarized whole case. Because your lordship will examine that part only. Not say whatever we like, whatever they like. Only examine to that part. See page 231. the 4/6/2024. This is file order 6 rule 17 for amendment of the plaint because they have filed a counterclaim. Right, my lord? See, my lord, in a matter of at page 231. See 231 forceful, forcible, illegal disposition of defendant number 2 counterclaimant from the counterclaimant so and so of land by plaintiff after filing of WS counterclaim dated 3/1 on the strength of false fictitious FIR dated 6/12/2023 filed only by plaintiff number 3 before OC Bharalemu, upon which so and so registered so and so, summoned some, arrested so and so. So now, if your lordship please look into at page 236. See page 236, para 8. Para 8, that after para number 44D, the petitioner defendant number 2 counterclaimant intends to insert the following paragraph as paragraph number 44D1. Now, that during pendency of the suit and counterclaim, the plaintiff had forcefully and illegally dispossessed the petitioner defendant number 2 counterclaimant from her possession of counterclaimant schedule 10 plot, so and so X plot of land and structure. Hence, now the petitioner defendant number 2 counterclaimant prays before this honorable court to pass a decree for recovery of possession of counterclaim so and so plot of land and structure by evicting man materials and belonging to the plaintiff therefrom, and also by removing, demolishing all illegal construction of plaintiff plot of land and structure, and cast and vacant possession of same may be delivered to the petitioner defendant number 2 counter through the belief of this honorable court, and if required with the help of armed police forces, Mandal assistant at the cost of petitioner defendant number 2 counterclaim. Now 44H, petitioner defendant number 2 counter prays for decree of recovery of possession of counterclaim so and so. And if you go down below, that is H and V, recovery of possession of a counterclaim schedule plot of land by evicting material belonging to plaintiff therefrom, removing, demolishing all so and so, so and so. So now, why I am showing this, my lord, on 4/6/2024, this applicant means, my lord, after the FIR was filed, and they, my lord, on the FIR, they, my lord, the possession, we were in possession, they try, my lord, to now file an application under Order 6 Rule 17. And they prayed before the court that this is what has happened. I have been dispossessed, now praying for recovery of the possession. Now please amend the plaint, the counterclaim. You please amend it. This is what they have filed on 4/6/2024. Please see the date. And this application, my lord, was for 1 year. They withdraw this application on 17/7/2025. 17/7/2025. Now that your lordship will get it. Now, if you see the withdrawal is at page 242. Please see 242. They have withdrawn on 17/7/2025. So it is an admitted position that you were never in possession. 17/7 they withdraw the amendment application. Now, when they withdraw this amendment application, my lord, they file application for injunction before the court, which also was withdrawn. That is 286. Please mark that. That is 9/9/2025. 17/7/2025 was the application which they have filed. If your lordship see at 286. Only one more date I will show at page 286. See page 286. See on the right hand side of 286, my lord, on top. See the date 17/7/2025. Lordship got it? On the right hand side, on the top, in the court of 17/7.
It's not lazy.
286.
Yes, 17/7/2020.
Yes, they have withdrawn on that day because an injunction application was filed on 6/6/2025. That miscase 6/6 of 2025. They have withdrawn the amendment, my lord. They have filed this injunction before the court on 17/7/2000 on the day of withdrawing it. Again, this application was withdrawn and withdrawn on 9/9/2025, my lord. Please see page 320. This injunction application was withdrawn by them at page 320. See, my lord, at page 320. Nine 2025 withdrawn. Right, my lord? 9/9/2025 at page 320. And they filed another injunction application, mid-J case number 852 of 2025. That is page 321. Now these are list of dates. I said these are 4 important list of dates. One is 4/6/2025. I'm just again repeating, my lord. 4/6/2025. Amendment 4/6/2024. Amendment application where it is admitted position that you were not in possession. You sought for recovery of possession. That's correct, my lord. Recovery of possession. You sought for amendment of the counterclaim also. 1 year you stayed. You did not do anything 1 year. After 1 year on 17/7/2025, you decided to withdraw it. And on the same date, you file an injunction application 6/6/6 of 2025, where you decided to withdraw. And 9/9/2025, again you file the present injunction application, which was moved by you in the court. Now, based on the injunction application, the order was passed by the learned trial court. Now, please see the prayer in the injunction application that has been moved by them. See, 321 is the injunction application, my lord. 321, lordship got it?
Yes.
And see what they have made a prayer at page 321 in the matter of, kindly see, an application so and so on behalf counterclaim, including temporary injunction, inquiry, temporary mandatory injunction, other consequential direction, urgent interim injunction against the plaintiff. If lordship reads, I will not trouble the court by reading the entire injunction application. Your lordship will find, please read, my lord, your lordship can read this in. What I find very inconsistent. In one hand, they are saying they are in possession. We are trying to interfere with their possession. One hand, they are saying they are trying to disposes us from the suit property. If your lordship kindly look into their statement which has been made, as if one hand they are saying no, we are not in possession. One hand they are saying we are in possession. They are trying to dispose us from our possession. See the entire statement which has been made by them. Now, what is the prayer they have sought for? And what they see at 323, 323, 1D, kindly see what they are seeking for. D. See D, my lord. An order of ad interim temporary mandatory injunction directing the plaintiff, see at 323, they're directing the plaintiff, their representative agents, affiliates, servants, partners, assigned successor interest, heirs, any person acting in concern of the plaintiff, directing them to remove all banners, movable temporary fixtures and other article left or placed upon or inside the suit property by the plaintiff. If you are in that suit property, there is no question that you are asking a mandatory injunction to remove all these banners. You are in that property, you are saying. You are stating yourself in this that you are in property. How you entered into that property? Tell us. You said a lot of things against us. How we entered? How you entered? Because 4/6/2024, you are never in possession. That's what your case, amendment you filed, and you said that we have been dispossessed. Now, I know, my lord, when it is a dispossessed, either you file a suit under section 6 and also press for a mandatory injunction under section 39. Or in a counterclaim also, you can amend the plaint. Counterclaim. That's the procedure, my lord. That's why I said, man, it is not a writ court. It is a civil procedure court. One has to go by procedure. The learned trial court, now I will make a submission, without following the procedure, has entered them into possession. That's the whole difficulty, my lord. That's why I am before this court. Now I am asking, can the learned trial court enter, saying what, my lord, I will read the order. Say, you cannot remain in possession. Meaning there when I was in possession, now learned trial court, no, you cannot remain in possession. How can you remain in possession? This I will read the operative portion of the order. So my argument will be restricted to their injunction application. What is your prayer? Your prayer is inconsistent. Number two, your own amendment application, which you know that if I go by that procedure, my lord, it will take a lot of time. Because your lordship knows when an amendment application, I'll get a chance for filing an objection, it will be heard, and thereafter amendment will be allowed. So this takes a time. A civil procedure court always takes a time. There are procedure itself we follow. Your lordship also cannot say that no, I will not follow the procedure. Your lordship knows that is a time consuming. Other side is taking time also, your lordship knows. Only to some extent to defeat the case. Your lordship knows very well. But your lordship hands are tied. Because all by procedure court, one has to go. So what I found in this case, that you moved an application, correctly you moved the application on 4/6/2024. Very correctly you moved. That yes, my lord, let us put in this way, my illegally has been entered. Now, can your lordship say, no, I will remove them? Your lordship can't do that. Your lordship will say, they will come with an application before the court. They will say, look here, there is some order passed by the court under Order 39, Rule 1 and 2 for restraining, not to disturb the possession. Now, during the pendence of the suit, I thrown them out. What is the alternative? Alternatively, I will come to the court, either for help, they restore my position back. That I have to do by procedure. Either I file section 6 with a new suit with my lord section 39 for restoring, or file an amendment application there itself and saying that recovery of possession and also for granting of mandatory injunction. I have to make a prayer in the main amendment application, it has to be allowed. There is no prayer. If your lordship looks into it, can they come with an injunction application without a prayer in the main suit? In the main, they have withdrawn that. How the court, now my question answer is that, how the court has granted a mandatory injunction. I'll show how it has been granted. Now, if your lordship looks into their prayer at 358, kindly see their prayer in the injunction. Then I will read the order in what manner it has been passed. See the 358, their prayer in the injunction. See, very interesting, 358. See A, my lord. An order of temporary injunction against the plaintiff, their representative, agents, affiliates, servants, partner, assigned successor, in the interest as or any person acting in concert with the plaintiff restraining the ingress into egress from and otherwise interfering, disrupting, and or disturbing the defendant number 2 appellant peaceful possession of property collectively comprising one parcel measure so and so, so and so, so and so. Now, my lord, I'll put a question here. How you are, that means you are, how you enter into position? Tell us. 4/6/2020, it is your own amendment application, which you withdraw. That means you want a shortcut method, not following the procedure of law. And you file an application, one after any application, you withdraw it. You withdraw the amendment 4/6/2024 on 17/7. You file an injunction application on 17/7, withdraw on 9/9, another application file. All in a shortcut method, you want that we have to be put back into position. And their prayer in this case in 359 was not to disturb the peaceful possession. See that, my lord. Their prayer is that. Now, if you see at paragraph 360, kindly see paragraph D, my lord. Now they are asking for a mandatory injunction. See, page 360 at para D, an order of temporary mandatory injunction directing the plaintiff, their representative agent, affiliate, servant, partners, assigned, interest, acting in concert with the plaintiff, directing them to remove all banners, movable, temporary fixtures and other articles left or placed upon or inside the suit property or in connection with by the plaintiff pending the disposal of the present suit and counterclaim and so and so, so and so. And they have made other prayer also. And 362, pending, they said that defendant number 2 applicant peaceful possession of so and so entering into and existing from otherwise interfering, disrupting and or disturbing the defendant number 2 applicant peaceful possession at 362, my lord. So basically these are the prayers which they have made. And your lordship, I have not trouble read the whatever the statement they have made, very inconsistent statement. One hand they are saying something in one paragraph, another paragraph they are saying something else. Now we file objection and thereafter this injunction order has been passed. Now, they read the injunction order. I will not trouble because your lordship has looked into it. Please see 442. This is very important, my lord. 442. See 442, my lord. And see on top. The complex and peculiar factual metrics of the case necessitates the intervention of this court in the form of temporary and mandatory injunction against the plaintiff at this stage. So my prayer, humble, my submission will be, the court could not have passed, my lord, subsequent order, kindly see. The court said now we have to enter into this aspect of the matter because of the complex and peculiar facts of the case. We have to protect one, a temporary and also a mandatory injunction. Now, what is that? My lord will kindly say. Any order of denial of temporary injunction at this stage may cause irreparable loss and injury to petitioner defendant number 2 and will lead to multiplicity of the proceedings. Further, the plaintiff cannot be, now please mark this, further the plaintiff cannot be allowed to remain in possession as it will amount to allowing a party to take benefit of his own wrong. Now, I'll pause for a moment, my lord. These 3 lines, following further the plaintiff cannot be allowed to remain in possession. Meaning what? I'm asking myself, what is the meaning of it? The meaning thereby we are in possession and we cannot allow you to remain in possession. Can the court pass this order? I am asking myself without a prayer in the main suit, the counterclaim. And mandatory injunction, your lordship knows, it is more than a prima facie case. Where is that? It is not an order 39 rule 1 and 2, my lord. I could have understood it is not it is a mandatory injunction. It is more than a prima facie case. Your Lordship knows I don't have to show all the judgment. When a mandatory injunction is taken by the court has to look into more than a prima facie case. Where is that? Not a single whisper. And when you read this order, it appears that we cannot be allowed to remain in possession. So by this order, can we be thrown out? Where is that prayer, my lord? Where is that prayer in the injunction application, my lord? There has to be prayer in the injunction application. I have not seen any prayer in the, your lordship will please go to the prayer. If I have said something wrong, my lord, then your lordship will negate it. I have read the prayer. I don't want to waste time. That's why I have said, what is a prayer? They want a restraining order. They want. They want that picture, furniture, banner should be removed. That's why they were asking. Where is the prayer? That the court is passing further, plaintiff cannot be allowed to remain in possession as it will amount to allowing a party to take benefit of his own wrong. My lord, we are in possession. Can the court, without making a main prayer, without a prayer, can the order pass? It can be passed. Now see, my lord, in fact, in media case number 824, a plaintiff while admitting possession of defendant number 2 has prayed for temporary injunction, restraining the defendant number 2 from alienating the sued land and proceeding with any construction over the same till disposal of the state. What the court is trying to say? You file an application, 824. There what? What you said? Not to disturb, not to from alienating the suit property and proceeding. Maybe I made a prayer. Is there any order passed by the court? No order has been passed. This is the first order that has been passed by the court. This was the first order passed by the court. So my humble prayer is that this order could not have been passed by the learned trial. Putting, like my lord, they have been put back into position. And they could not do it. That's the whole case, my lord. There is no prayer at all to restore the position back to them. And the court is saying that no, you cannot be allowed to remain in position. This is a judge with great respect making a third case of his own. A case has been made by the court itself. No, you cannot remain in position. That's the observation and finding. Then thereafter, my lord, and said that no, there is an injunction applying which you move. And what you said not to alienate the suit property. This is what you said, meaning that we implied that you are not in position. Kindly see, the said petition is pending. If the plaintiff were really worried about the protection of the suit property, they ought to have moved an appropriate application before the court for the same. Instead of taking, my lord will kindly say, instead of taking his point directly without the leave of the court, and their action cannot be allowed to perpetuate. Very nice, very well. My lord, this court, let us accept that we have taken into possession. Now, is this a procedure of the court? No, you did not make any prayer, but I see that no, I'll put them into possession. This is what exactly it has been done. My lord, facts, my lord, definitely the facts has to be looked into. But in what manner the injunction order has been passed? Now kindly see, kindly see para 22. Considering the above facts and circumstances, the court hereby directs the plaintiff to keep their hands off the suit property and not to interfere in possession of defendant number 2 till disposal of the suit. So ultimate paragraph is that you lay off your hands. You go out from that premises. Lay off means you go out from that premises. And don't try to ever interfere with the possession of the suit premises. That's short and substance of this order that has been passed. So my submission will be in respect of this, because I moved that FAO. Your lordship will restrict to the injunction order that has been passed. One, my lord, your lordship will look into their injunction application, what they have made, what statement they have made. Whether any statement has been made, they have been thrown out. Because lordship will kindly note down, from 4/6/2024, they were never in position. Then where is the question that you entered to? In what manner you have entered into position? I think while hearing the matter, in this case, by this court, rightly has passed the status quo as on today shall be maintained. Status quo as on today shall be maintained. My lord, it was heard. It was heard for 2 hours in this case. And ultimately, court, my lord, has granted a status quo as on today shall be maintained on 26/11/2025, my lord. That is the order that has been passed by this court. Now, my lord, I will show, my lord, your lordship will kindly take the specific relief act. And also, no, there are 3 types. One, your lordship knows. One is a temporary injunction. During the pendency of the suit, till disposal of the suit, a party is protected by way of a temporary injunction under Order 39 or 182. That's one. Another is a perpetual injunction. Your lordship knows that when a perpetual injunction can be granted by the court, that is only can be granted by decree made at the hearing and upon the merit of the suit, perpetual injunction. And on what are the conditions that can be passed by the court in perpetual granting of perpetual injunction is section 38. Now, we are concerned about 39 because court has exercised its power under 39. One is, if the court should have said that don't interfere with the suit property, restraining the party not to interfere, that would be a separate issue. The court has gone beyond one step, granting of a mandatory injunction. I cannot remain in position. That's the clear finding. I have to be thrown out from the position. That's the finding of the learned trial court. Before ending it, that paragraph 27 or 28, paragraph 22, prior to 3 lines prior to that, the court said that instead of taking position directly with the leave of the court, you cannot have taken how you entered into position. You should have taken leave of the court. How can you enter it? That's why I am granting a mandatory injunction. You are also not in position where you are in position from 4/6/2024. The best part would have been status quo as on today shall be maintained till disposal. Whoever with the suit property who are enjoying, they will enjoy. Status quo as on today shall be maintained. Now, what is important in this case, my lord, is section 39. Please see section 39 of the specific relief act. Because this is a temporary mandatory injunction which is granted, and they made one prayer. They have never prayed to restore the possession. Now see, my lord, when to prevent the breach of an obligation, lordship got it?
Yes.
It is necessary to compel the performance of certain acts which the court is capable of enforcing. The court may, in its discretion, grant an injunction to prevent the breach complained of and also to compel performance of the requisite act. So, what is most important in this mandatory injunction? There has to be, my lord, whenever the matter comes up before the court has to look into it. No, yes, this is some protection we have given to a party. And this was an obligation. Say I am a defendant, I am thrown them out. I am putting an example. And there is a protection which is given by the court to the plaintiff. He comes that no, that this should not be, not to interfere with the peaceful position by the defendants. Now, so it has casted an obligation by the court to the defendant. I'm clear, I think, my lord. Cast an obligation to the defendant that yes, look here, that is an order of the court. Do not interfere with the position of the plaintiff till the disposal of the suit. By the time what it has been done by defendant has thrown out the plaintiff from the suit premises, even in spite of an order passed by the court. So there was an obligation. So to prevent the obligation, my lord, kindly see the word. When to prevent the obligation of an obligation, it is necessary to compel the performance of certain acts which the court is capable of enforcing. Then only the court is capable of enforcing. My lord, it is not that I come with an application before the court I said, no, please grant temporary mandatory injunction. Please grant it. Court cannot grant just like that. The court has to look, because my lord always knows the mandatory injunction is always more than a prima facie case. There, I don't want to trouble all this judgment when a mandatory injunction can be granted. That's why I read what is section 39, my lord. Where is that? My lord, they have to show before the court that there was some obligation, before the learned trial court. So, to restore them into position, there has to be some obligation. And that obligation, my lord, I have breached. Because I know very well that court has asked me not to interfere. There's an obligation. But I breached. Then the court is compelled to pass an order restoring the position back. That's what the mandatory injunction is about. Where is that, my lord? Is this a case which they have made out in an injunction application? That no, we have been thrown out from their premises, please restore. Then how come the learned trial court has ignored the principle of section 39? That's the crust of the matter to decide. How come the learned trial court has ignored the basic principle of section 39? The learned trial court, with great respect I am saying to a learned trial court, could not have ignored the principle of section 39. By mere filing an application, my lord, what they have done, which they cannot do it directly, has been done in direct manner. Because direct manner, if it will be done, then it will take a lot of time. That's why they know best is that let us withdraw that application, amendment application. If that amendment application would have been there, some type of order would have been there, then I could have understood. Here, section invoking of mandatory injunction by not complying section 39, that is fatal. That could not have been passed. This order, not status quo, this order absolutely is arbitrary, and this order should be set aside. Forget about the status quo order, my lord. This order should go. Where is the question of giving relief by way of an injunction application where you don't make a prayer of a mandatory injunction? What mandatory injunction you prayed for? You may pray for mandatory injunction for removing all the banners, pictures, fittings. This is what you are trying to do it. And my lord will kindly see the judgment which they have shown, my lord. Now the judgment which they have shown in respect of the mandatory injunction. Yes, please look into that order, judgment. No, cause. Wait. My lord, to connect this, I cited one judgment. I don't want to repeat that judgment. When a mandatory injunction can be granted, that is judgment. Just please note that judgment. Yes, judgment. 2025. I just in 2025. SC, live SC, page 700. I think that judgment I have cited already, my lord. I don't want to repeat, my lord. That judgment.
You already
filed? Okay.
No, if you have filed earlier, it is there with us.
Yes, yes.
File earlier.
Yes, I have filed. This is the case. We have filed, my lord. We have filed, my lord. Earlier itself, 2025 live law SC 700. Please, my lord, why? Because mandatory injunction I am connecting to the order of the learned trial court. So because 2025 live law SC, Estate Officer Haryana Urban Development, 2025.
SC 7. Yes, yes.
74.
Yes, yes. It is 74,
74.
75, 76.
Yes.
I have already.
76, my lord, we see that. 76, how Supreme Court, what is the obligation? What is that breach has been explained by the Supreme Court. That's why I I showed my lord section 39. And when the order has to be passed by the court. By merely you cannot restore somebody back to possession. Well, that will be a chaotic condition, my lord. If this is done without following the procedure, my lord, maybe, my lord, let me say that somebody illegally has trespassed into it. That doesn't mean that the court will say that no, we'll restore the possession. There is so many cases, my lord. I remember when in the trial court, we used to file some suit, a suit only for injunction against the landlord. And you say that don't disturb without my lord, my peaceful position, without evicting me, with due procedure of law. Court protects us, saying that yes, maybe I'm an illegal trespasser, I've entered. No relation with landlord-tenant. Then landlord issues a notice to me, saying that you have to vacate the premises because you are a trespasser. No relation with landlord-tenant. We go before a suit for injunction. And court said that yes, you cannot evict them without following due process of law. What he does, file an application under my law, under Urban Area Rent Control Act for eviction. So this is what, my lord, when you have to follow the procedure, it is not that somebody is in possession, you just throw him by way of that injunction application. This is what the Supreme Court said, that all procedure under section 39, obligation breach has to be looked into, then the court can pass the order. So this is what, my lord, about the mandatory injunction passed by the Supreme Court. And their judgment, Dorji ki asal itu? Court asal itu? No. They, मैं तो note था asal. Seeing we said no. They cited one judgment, my lord. Their judgment is Dorab Koswaji Warden, 1992 SCC, page 117, my lord. Their judgment is completely on a different footing altogether, because one second, my lord. If you see that, my lord, paragraph 16, they relied paragraph 16 of 1992
SCC.
1992 SCC, page 117. They relied 1992 SCC 117.
Yeah, no. 1992 SCC
1990, they relied, my lord. ऐसे नहीं क्या हो रहा है टाइम दिया ऐसे नहीं ऐसे नहीं कुछ ऐसे नहीं क्या ओके
We are saying they have relied.
They relied. They are given in a bunch, I think.
Yes, that's what we are checking.
This is 1992 SCC 117. Yeah. This is a bunch, I think they have given to us also. My lord, will kindly take this bunch, I think.
Oh, yes.
My lord, only please note down, they relied para 10, 15 and 16.
Yes, 10, 15, 16.
Now, my lord, what they said in paragraph 16 is that the relief of interlocutory mandatory injunction granted generally to to preserve or restore the status quo of the last non-contested status, which preceded a pending controversy until the final hearing, when full relief may be granted, or to compel the undoing of those acts that have been illegally done, or restoration of that which was taken from the party complaining of. So, my lord, where is that complaint? My lord, I am putting my question, where is that complaint? You complained. Rightly, you complained before the court by filing that application on 4/6/2024. Your complaint has been withdrawn. Where is that complaint? The genesis of the judgment will not stand. There has to be some complaint. If not that injunction application you come, where is the main prayer in that amendment? That's why they have withdrawn it. Smartly they have withdrawn it. They know that these are process which takes a time. So let us, in a shortcut method, let us file an injunction application. Where is the complaint? There has to be complaint to restore the position back. Not by way of an injunction, temporary mandatory injunction, we want, please remove them. Then each and every case will be so easy for the court without going into litigation, my lord. Now, our answer will be, paragraph 10, 15 and 16 will be, the judgment is not applicable in our case. As because they themselves claim in the prayer of injunction application that they are in possession. They themselves have stated that we are in possession. Where is the question of the court exercising the mandatory injunction? You don't remain in possession. Throw them out from the possession. Lay off their hands. And the respondent, they argued that interim mandatory injunction can be granted to restore status as on date of filing of the suit. My lord, here I'll add, they did not complain about disposition in the injunction application. Please note, that is so important. They did not complain about the disposition in the injunction application, which earlier they complained. That means your entrance itself was illegal into my possession. How you entered? If you are not in possession, the respondent didn't complain about disposition in the injunction application. Therefore, my lord, the learned trial court granted an interim mandatory injunction for restoration of which was not even asked for by the respondent and apparently beyond the pleadings. That will be my answer, my lord. That's why I read those important paragraphs, the last two paragraphs, how it was dealt. The relief of interim injunction, my lord, mandatory injunction, can only be granted when there is an injunction order and if the party violates the injunction order, then a status quo ante can be granted. So there is no violation of the injunction order, man. Today you have come and prayed that there is a violation of the injunction order. I'll later deal with that, my lord, their application or therefore violation of the injunction order. Now, my lord, decision so relied by respondent principle so held in the above judgment, these are not applicable because of 2025 judgment. Now the judgment now is completely has been changed. What was there in 1990, that is complex and changed, my lord. So this is a quick, my lord, I am giving reply. Now, going back in 2-3 lines, my lord, I will just reply to their judgment which they have placed, my lord. My lord, I don't have to say much of the first two judgment. If you are holding this bunch, 8 bunch, my lord, you don't have just the judgment which they have, index has been given.
Yes.
You just go to the index, my lord. First two judgment, wonder and talks that normally we in the trial court, we show in the trial court 1990, I think, if I am not wrong, yes.
Yes.
Supplementary, paragraph 14, I remember, my lord. You cannot substitute the finding of the learned single judge. You cannot do it. That basically is that. I don't know how it is relevant because here the facts is completely different here in this case. So wonder versus entox, my lord, may not be so help in this particular case. Ramakant Amela Sosi versus also that I think power of the appellate court. All these are the power of the appellate court when it has to be, its limited power has been given. by the judgment, when it is to be exercised by the appellate court. You cannot substitute the judgment of the learned single judge or trial court. His high court means learned single judge. So I think these two judgments will not help in this case, because here our case is about granting of a mandatory injunction where there was not a prayer which has been made. So acted beyond the jurisdiction of the learned court below. These two. Dorab, for Kawasi or Lordship, I have shown that this is about mandatory temporary injunction can be granted to restore status as on date of filing of the suit. That already I have, my lord, I have shown before the court. Next, my registered sale deed carries formidable presumption of validity and genuineness. Hemlotter versus Tukaram, they have, my lord, cited, and they said registered sale deed carries a formidable presumption of validity and genuineness, cannot be displayed without a trial. My lord, here we are only questioning, our answer will be, we are only questioning the manner in which the sale deed has been obtained, which we can show prima facie on the face of record. That's our submission. This. Now, my lord, next judgment is correspondence so and so, education institution so and so. This is suit for injunction not maintainable without seeking declaration of title. Our question will be, our answer will be, this is not a suit of injunction simpliciter, my lord. The appellant here not only sought for declaration, but also has sought for relief for cancellation of sale deed and mutation order in their plan. So this is a matter of trial, my lord. This is not a suit of injunction simpliciter. We have prayed for before the trial court in the main suit, and that will be decided by the trial court in due course. Now, next, coming to that, my lord, third judgment, Smriti Devram versus Prabha Ranjan Devram, that they said the plea of the plaintiff did not have the right to sue is not raised in the written statement. The respondent only made averment that Subhadra Medi did not have any title on the date of execution of the will. Our answer will be that we have a right over the property as per the Hindu Succession Act. Prior to the sale deed, which was executed in favor of the respondent, namely Sarita Devi Sechel. That we have a right. Because the sale deed which was executed was later on, and our suit was prior to that. So the pendency, it is a least pendant of the case. Now, next is about the conduct of the parties. Unclean hands. But sorry to say that a lot of things they have said in this case, they have not come with a clean hands. If they have, and all contradictory statement they have made. If they have come with a clean hand, they could not have approached the learned trial court in a very shortcut method without, my lord, pressing that the amendment application. Very shortcut method. They have come, not a clean hand. There is a contradictory statement in each of the injunction application. Once they are trying to move that matter, again they try to withdraw it. Another application has been filed. One after another application they are filing and changing the stand throughout. Now, my lord, this is what, and my lord, they argued and my lord, they argued as if it is a mini trial. They argued the merit of the case. Lot of things had been said. But what is this blood? Full blood, half blood, no title. This is not where your lordship is not adjudicating the matter. It's not a mini trial. Before, it is not a mini trial. We are confined to the injunction application. So all the judgment which they have cited before this court is not applicable in the present case, my lord. And very quick, my lord, our judgment which we have placed before the court, I just made a note out of it. Other side of the all the judgment already cited, my lord. So I didn't make a like this list. Kindly see, my lord. This is estate officer 2025, my lord. Condition for mandatory injunction. Lordship got it. Second is Om Prakash, relief not paid for suit not be granted. Disposal amount to new cause of action, only recourse to file amendment or separate proceeding. Now next, 2022, relief not found on pleading should not be granted if a court grants a relief for which no prayer was made, depriving the appellant for an opportunity to oppose such relief, it would lead to miscarriage of justice. This is happened to us in a present case, my lord. Now, 4, a litigant cannot take contradictory stand in the same case. A party cannot be permitted to approbate and reprobate on the same facts and take inconsistent shifting stands, which they have done in the instant case. Please read the injunction. Your lordship will find what stand they have taken, shifting stand, and their amendment application, which is on record. They may withdraw it, but it is part of record. They cannot take a shifting stand. Whenever they like, they will take this stand. Whenever they like, so approbate, reprobate, you are not allowed. Now this is important. Returner consultancy. Internal relief cannot be beyond the scope of suit. Correct, my lord. That's the right proposition. You cannot get an internal relief which is beyond the scope of the suit. Now this Siddham Sethi, 2024, doctrine of lease pendant, respondent purchased during pendency of probate proceeding. This is what I said last, my lord. And last judgment, 2025, a registered will carries a presumption of genuineness. See their judgment, my lord. I think that's not a part of the paragraph 9, my lord. I will not read that, my lord. Paragraph 9. No. Paragraph 9 can be taken. That's a last judgment which we rely. Paragraph 9. Now, in violation of court rule. Now, 1 second. It will lose it. My lord, I think this is done. So far as the, my lord, I'll take 20 minutes in just giving a reply to their violation. I have not taken much time, my lord. It is 3:25, 3:35. So I restricted my argument, my lord. Let me put in this way that yes. No violation. No violation. My lord, see their application of violation. Please see their application violation of the order. Well, what is a violation? Well, I don't understand. What is a violation? My lord, before your lordship takes up, I am putting a question myself. What is a violation? Violation order 39 rule 2A. Violation, they have brought 3 counts. 151, order 21 rule 35, and order 39 rule 2A. I am asking what is a violation of the court's order? Is a violation of status quo order to be maintained is a violation of the court's order? Or you want to say that after status quo as on today shall be maintained, we were in position because we have given photographs before the court. All the photographs has been given to the court. Your action was bad because with collision you went, you have thrown me out, and that is a status quo order as on today shall be maintained. This you have filed, and you said there is a violation of the court's order. I am asking myself, what is status quo as on today shall be maintained? In a plain language, I understand whoever is in possession, they will remain. Whoever is in possession. The court hears the matter, my lord. My lord, your lordship will please take into mind the order of the learned trial court merges with the interim order that has been passed by this court. They cannot go back and rely the order of the learned trial court. We have challenged that.
But whether you were in position in, as per the observation made by the learned trial court.
We say that we are in possession of the suit property.
But the
we-
observation is says.
I'm sorry.
The observation of the learned trial court below is not in the case that you are in possession.
No, observation of trial court is said, if you read that, we are in possession. Kindly see, my lord. See the order of the learned trial court. Please look into it. Learned trial court, my lord, said that lay off your hands. Kindly see, my lord. You don't have to just take this, my lord, now last. See that, my lord. Further, the plaintiff cannot be allowed to remain in possession, as it will amount to allowing a party to take benefit of his own wrong. Now, what the learned? The state petition is pending. If the petitioner really worried about the protection of suit property, they ought have to move an appropriate application before the court for the same, instead of taking his possession directly without leave of the court. What means, my lord? What I understand from the language of the learned trial court, that what you could not have, how you have taken the possession without leave of the court. And I am asking, how you entered into possession when you have been dispossessed on 4/6/2024? This is what I am asking myself, my lord. And it is on record. 4/6/2024, you have been dispossessed. That is your amendment application, recovery of possession, prayer of the amendment. Then how could you have entered? We were in possession. That is why, my lord, the learned trial court now passes an order. If you see at before 22, my lord, before 22, my lord, the said petition, if the plaintiffs are really worried about the protection of suit property, they ought to have moved an appropriate application for court for the same, instead of taking his possession directly. So who is in possession then, my lord? Can they say that we were in possession? And how the court, this is my lord answer, how the court could have passed that order of granting mandatory injunction where you don't make a prayer? My lord, it doesn't make. This year, in the injunction application, very smartly, they are not saying that I have been dispossessed on such and such date. But in the amendment application, they say 1 year they remain silent. 1 year. Then 9/9/2024, 5 they file this injunction application. So my understanding, subject to what your lordship decide, my understanding of this paragraph is that this is the clear cut of the learned trial court also, that how you remain in possession. You cannot remain in possession. This is what the learned trial court. And this order has been put to challenge before this High Court. Now they cannot rely on an order of a learned trial court, which merges with the order of the interim order that has been passed. Of course, your lordship has to decide that. I am not saying that your lordship status quo, whatever your lordship sees that no, this is a case where we decide that injunction should not be interfered, or this is a case where injunction should be interfered, or this is a case where status quo as on today shall be maintained till disposal of the suit. These three, either of these three, your lordship will decide. Either nullified my contention, which I have made, or say that no, this order itself is bad, or status quo as on today shall be maintained. So my submission, going again, given answer to your lordship, is that the order of the learned trial court clearly says that we were in possession. So that is why ultimate paragraph is a lay off your hands. Don't try to interfere with their possession of property. This is the finding. Now, while going by the injunction, there.
And then what do you mean by lay off your hands?
Lay off your hands, I cannot till the disposal. Lay off means, please do not put your hands into the position. Do not put hands into a position. Please lay off. Don't try ever to lay off your hands into the position. And don't interfere with the position. That's what I have understood. That's what
don't interfere with the
position.
Position of whom?
Position of them, defendant. Don't try to interfere with their position. Then, that's what I am saying, my lord. No, what I am saying.
In one hand, you are saying that you were directed to lay off your hands and don't make any interference in their position. That means they are in position or what?
No, I am telling you. Now I'm asking, I'm putting a question, my lord, myself giving an answer. That's what precisely I am saying. Can that order be passed? I am in position. Can that order be passed? If I am in position without making a prayer by them. My lord, there has to be prayer
That you
made by
lay off
them.
your hands and all.
Lay off the hands, they have to make a prayer in the injunction application. Where is that prayer? My lord, is always we understand that always it has to be followed in the main suit. Then only you can make a prayer in your injunction application. Temporary, mandatory injunction.
That is there.
So, my lord, can an order be passed? Lay off your hands. Please do not try to interfere with the possession. You lay off your hands when I will be dispossessed. Which date? Why restoration of possession? Why to remain lay off in my hand? What is the reason behind? Simply because the injunction application is filed and a relief will be granted. My lord, my lord, your lordship can put me question. I'm very happy that your lordship. Then I can give an answer to it, my lord. Otherwise, it will remain. Your lordship can put. I can give an answer to it, my lord. Whether your lordship accept, that's a different thing altogether. But I feel that once, that's why I have read section 39, my lord. What is temporary injunction, perpetual and mandatory injunction? Well, mandatory injunction is, I think, is something you are restoring the possession. Status quo ante, giving back the possession.
Yes, yes.
So just like that, my lord, plain injunction application, moving and saying that no, even if you are in possession, you cannot remain in possession. This is what I read. 4 lines I have understood that. Now let us put in this way, my lord. Very shortcut method, a person enters into possession. Let us say that he enters into possession. How the court will restore the possession back to that person? Suppose A has entered, now B comes and they say restore the possession back. How? It has to be by filing a suit, by making a prayer in the suit, then followed by a mandatory injunction. Court can hear, where is that? So if that is not there, my lord, then if the order of this court, status quo as on today shall be maintained, where is the question of violation of the court's order? What they are saying, they are relying on the order of the learned trial court. This is what the learned trial court is saying. So there is a violation under Order 39, Rule 2A. Now, my lord will kindly see. CPC. My lord, application.
Yes.
151.
Is there any other matter? Any counsel is waiting for any other matter? That won't reach it. Item number 32. We will give a date, will accommodate. And anyone is for 33 also? No. For 33? You are for 33? No. No. You are for item number 32.
Oh, 1 minute.
Any admission matter is also there? 12. So this will be in that case, in fact, while rising at 1, I just give an impression that if the partner matter starts, then it won't reach. So now these are the matters of the 4 admission matters where the would be all adjourned. So try to accommodate with the court master. If we can manage a date, then we'll do that.
My lord, will one humble submission. Your lordship will not rely on throwing papers on that side, photographs, video. I have also photographs, video. How they entered, I have also have that video. I said, please do not, please pass on the court. We don't want to prejudice this court by this type of throwing papers. They see, this is, I have. If your lordship wants, I can. But these are not admissible. How can it be admissible, my lord? And now your lordship knows, see the new law, and they corrected. They want to say 63. No, please see the new law now. If a photograph is given, If a video clipping is given by a pen drive, it cannot be admissible under the Evidence Act. Under the new law, kindly see my. See the provision 63(4), kindly see my lord. 63(4) of BSA.
BSA is there? BSA এখন আছে নেকি?
Schedule দেখাবেন।
BSA.
63(4). Schedule
আর-
4 আছে, schedule 2 আছে না? কিসলে আছে না? কোথা আছে?
BSA.
এরা সব
মানে আগৰ এভিডেন্স খন BSA হ'ল। আগৰ অধিনিয়ম।
additional affidavit দেখা যাচ্ছে আমার। What they try to
60?
they
60?
section 63(4)(c).
60.
What they are trying to impress by showing photographs, saying, see how we have been dispossessed. They are showing some video clips. আমারও দেখাই দিও আছে দেখা এইবিলাক। You have also that video clips, but how it is admissible, my lord? How it is admissible? Kindly see 63(4)(c). 63(4), kindly see the schedule. Kindly schedule, my lord. Your lordship got a schedule? Section 63(4)(c), Part A to be filled by party. I so and so affirm and state and submit as follow. I have provided electronic record, output of digital record taken from the following device, digital record source so and so, computer, storage media, DVR, mobile, flash so and so. This is the Part A, my lord. Lordship got it? Now this is Part A, which they have provided. Please see at page 98 of the additional affidavit, my lord. Their additional affidavit at page 98. See, my lord, at page 98, certificate under 63(4), which is old than 64(c), not
Page number? Page number?
Page 98 of their additional affidavit, which they have filed.
Take it.
98.
It shall.
98 price. Additional affidavit. Lordship got it. This is the they file. It is file for 28/01/2026, ma'am.
98. The line starts from section 61.
Page 93.
93 or 98?
93, 98 is the 93, my lord. It starts from 1 second. It starts from 98 is annexure A23. Paisa nahi hai?
93 is annexure A10.
Annexure 90.
No, what is 93?
93 is the IA, additional affidavit they have filed.
No, what is it? What is it?
Okay.
Annexure.
So yes, contents is so about 63(4), my lord. Annexure A23. Annexure A23.
A10.
This is what they have given a certificate under section 63(4) of the BSA, my lord.
It's a certificate. Oh.
Yes, this is the this is they have filed. They have filed this application.
Anyway, what is it? Yes.
No, your lordship will kindly see the last, they have annex A23. See that, my lord. Which they have annexed, certificate.
A23. Yes.
Your certificate. Yes, I kindly see now 63.4C. 63.4C, my lord, of the BSA 2023.
Yes. Yes, I
Now,
have seen.
Palin,
Yes.
because all the time they are trying to show the videographs, they are trying to show the photographs, how we entered, we have also a lot of things we can show it. And please keep this also if your lordship want to see. But I am saying we'll give it. But neither of this party, these are not admissible. Because why it is not admissible? A23 kindly see, this is only a certificate which is given by them at part A. See at part A, my lord. Part A. If you see 63.4C, it is part A. See the schedule. This is 63.4C part A. And please turn this. And if you see part B, there is two parts. That is why 63.4C, C to be filled by expert. By giving this, the electronic record, digital record is not enough. From which device? This has to be certified, to be filled by expert. Kindly see, part B. I name so-and-so, submit as follow. Kindly see, they produce electronic record. Output, digital are obtained from following device, digital record source, tick mark, so-and-so, so-and-so. So, as applicable and any or relevant, if any about, I state that so-and-so is obtained through the following so-and-so, so-and-so. So here, what they have given in part A, they have not been filled up by an expert part B. These are also been properly, this is not been given. So if it is not given, any photographs, any digital form record, that is not admissible under this provision of the Act. In reply, we have written, my lord. We have given reply to this also. Yes, one second. So, my lord, this cannot be taken into account. If necessary, we can give it to all these photographs and video also, but your lordship will not take into account. It's not admissible. How they entered, how we were in possession, everything is there. They try to dispossess, there were videographs, photographs, they broke all the cameras. They broke all the cameras. And how they entered? Because they know they were not in possession. They were not in possession. This is a video is also there, my lord. They have given in a form, we can also give in form. So, but these ultimately it is not admissible on Evidence Act. Your lordship will not take into account. Now coming back to their application of injunction order, they have three, my lord, sections. One is 151. How is 151? I don't know. There is no question of 151 comes only when you need aid and help of the police, you have to restore the position back. Your next is Order 21, Rule 35.3. Order 21, Rule 35.3 is on completely on different. Only at passing a decree your lordship knows. That is also at the time of execution. So that is also not applicable. Third, Order 39, Rule 2A. Now, they have to take a stand. Whether Order 39, Rule 2A they will pursue or a contempt which they have filed separately, which your lordship they have never stated before this court. So whether we have committed clean hands or we have not committed clean hands. On the same date, they move a contempt before this court, High Court, kindly see. What I will not say in too many words, why they did not disclose this matter before this court. Why? A contempt has been filed. They know these applications are not tenable. It will not stand. What Order 39 Rule 2A will stand? Kindly see, my lord. On the same date they have filed. We have got that 19/1/2026. And this is a contempt, case 61 of 2026. Kindly see, my lord. And they are saying lot of things against us. We have not come with clean hands. This is the, and this is the, what they have done it. This is what? Clear cut a foreign shopping, my lord. Nothing else. One hand the matter is pending and one hand you go. Kindly see now their bona fide, kindly see, my lord. Is this, my lord, that has to be protected? All throughout fraud, sale deed, they go in a shortcut matter, they want an injunction, they should be restored back to the possession. Shortcut matter. They will go before another court, file a contempt when this application was pending before this court. It's very sad, my lord. They could not have been done in this way. So, your lordship, this application should not be taken into account as an application violation of the court's order. What violation of the court's order, my lord? How it was violated? And how this is applicable, my lord? All the three different provisions you have, you have stated here, 151, Order 21, Rule 35(3), Order 39, Rule 2A. And one hand you go, on the same date you file a contempt application before the High Court. And order, your lordship know, Order 39, Rule 2A, there has to be some evidence to prove that. They know that this will not stand. That's why very smartly they went and filed an application for Contempt Act under Section 12. They could not have gone to a particular court and they did not say anything about this contempt. All throughout, my lord, a proceeding, your lordship knows how many days the proceeding was taken up by this court. Not even a single day. Today we are pointing out before this court. It was their duty to point out before this court that here, yes, we have filed a contempt application before the court, before this High Court. So this contempt should not be taken into account, my lord. So Order 39, Rule 2A.
That contempt was filed on 19/1.
Yes.
And this
same date.
Same date. Because 21 one order was there.
Yes. Same date. We have given a reply. They know that how, my lord, how this contempt violation, Order 39, Rule 2A. There has been evidence, Order 39, Rule 2A. One judgment, last, my lord, of a contempt, 2009, 5 SCC, page 665.
Yeah,
My lord, please note that the contempt when they have filed, 19-1.
Yes,
this is what they have proceeded in all the manner in the trial court. They are saying lot of things against us. This is what, my lord, kindly see their bona fide. This is their bona fide. And they are saying that all suppression of material fact, all nullified. What nullified, I don't know. Which order has been nullified? As if everything is gone.
No. Obviously, on 21/2026, order was passed by this court, first
Yes,
order initially.
yes,
And that
same date.
this same day they have a file.
Yes, that's what has happened, my lord. Same date it was filed. Normally, my lord, when these applications, when it's a connected matter, we normally inform the court. This is what has happened. We have filed. My lord, you can file it, but please inform to the court when the matter was being heard. Is the same subject matter.
21.
On 21, your lordship has heard this matter. And your lordship will just last 2009, 5 SCC page 665. This one, is it? Photo?
Yes.
Please see paragraph 38. This is. The power exercised by the court under Order 39, Rule 2A of the Code is punitive in nature, akin to the power to punish for civil contempt under Contempts of Court Act 1971. Person who complains of disobedience or breach has to clearly make out beyond any doubt there was an injunction or order directing the person against whom the application is made to do or desist from doing some specific things or act, and that there was disobedience or breach of such order. While considering application order 39 Rule 2A, court cannot construe the order in regard to which disobedient breach is alleged as creating an obligation to do something which is not mentioned in the order or surmises, suspicious, and inferences. The power under Rule 2A should be exercised with great caution and responsibility. Now, if you see the order of this court is only a status quo as on today shall be maintained, not beyond that. So this application which they have filed, what they try, my lord, what I understand, what they understand, they want to show before the court all the video photographs, videographs. Let's look here. What has been done? This has been done. So now we pointed out by filing an affidavit saying that no, what you are saying, these are not admissible. There has to be a certificate. They come and they file this additional affidavit. Now 63.4, but not 63.4C. To be filled by expert, they have not done it. They know it. How can they do it, my lord? They try all to do all in a hurry up manner, my lord. They somehow they want that we should be added back into position somehow this way or that way. So I think, my lord, this is not a fit case to entertain this application under 39 Rule 2A. On the face of it, dismissed only on the ground they have suppressed before the court while the proceeding was going on. On this ground itself, their bona fide is not good, my lord. And how this, my lord, a relief can be granted where bona fide is doubted, my lord, when they doesn't itself come with a clean hands, and they accused of us that we don't come with a clean hands. At least we will not do it if some orders, if we move an application before the court. So I think, my lord, I'll conclude my submission before this court by saying that it is a case where, my lord, the learned trial court acted beyond its jurisdiction, my lord. That's my humble submission. Cannot act beyond jurisdiction. If you have acted, section 39 should have been followed, where in this case, section 39 for granting mandatory injunction has not been followed. I am thankful to my Lord has given so much of time to us, not once. My life, I am telling my Lord, I have not done an FO which takes about 1 week. Well, this is a kind enough that your Lordship has given time to us. Not one or how many, I think more than 2 weeks. And thankful to my learned, all my learned friends. They have assisted me very well, I am telling my Lord, because we don't get time to look into each and every paper, my Lord.
Good. Yes, Mr.
Yes.
You want to any reply? Make a reply.
2 minutes. 2 minutes.
I normally.
Because I'm conscious of the time.
Normally, my lord, there is my learned friend can, but I have not come any system by giving another reply by my learned friend. There is no, I think it is not allowed. He also knows. My Lord, Supreme Court doesn't allow a 2 minutes time also.
Reply, I think, yes.
That doesn't give any time. If he gives a reply, I will also give a
Sir,
reply.
let's see if I may,
Yes.
some new points have been raised,
Yes.
only that.
That's all. That's right. My Lord, only one thing. I can leave, my Lord, because I have to leave and go to Arunachal Pradesh, my Lord.
Today, by today?
Yes,
Okay.
well, because it has been fixed.
Tomorrow you are having meter.
I have a matter, my Lord.
Okay.
Well, I'll take your leave, my Lord.
This,
Is there.
nowadays too, you will reach within 4 hours, 4 and 4 hours, 4.5. But in the night time, we better
Yes.
post.
I take your lordship leave, my learned friend.
Who is accompanying with you? You're one of the.
will be there.
You're going. Yes, just for 2-3 minutes. That's
Just 2-3
okay.
minutes. That I am reading from, I won't disturb your ladyship with the page number. During the pendency of the suit, this has happened. That it is stated and submitted herein that after the arrest of defendant number 1 as well as the son of defendant number 2, scheduled land was lying unattended, and to protect the interests of the plaintiff from any third party, plaintiff came into possession.
You have
And that is the crux of the dispute. Everything which has followed, applications have been filed, some withdrawn applications have been referred to. Why withdrawn applications, that no orders have been passed on that application, that has been referred to. But this is the crux of the dispute. If they do not have any right over a land, they have admitted that I am in possession as on the date of filing this, can they enter into the land and disturb the possession in whatever manner? They may plant someone there, they may, because it's not a house, it is actually a warehouse. They may put a lock, they may put banners, they may disturb the possession in whatsoever manner possible, which is why the mandatory injunction, temporary mandatory injunction was required. And your ladyship will see the averments in my application. I have set out why the temporary mandatory injunction was required. It was a consequence of, for instance, your ladyship may think of a situation where the suit has just been filed, keeping everything aside. Because really, all of this does not matter in terms of who is supposed to be in possession of the property. May keep everything aside. Today, there is a piece of vacant. I have registered sale deed. I am in admitted possession. I obviously cannot, perhaps I cannot protect that land, or I cannot overlook that land or see that land on a daily basis. Some person without any right, without any established right, comes and starts squatting on that property. Does that mean that he is in possession? Does that mean that I have transferred possession to him? No. That is the crux of the dispute. And that is what the learned senior civil judge has adjudicated upon. The date of filing of the plaint, what was the situation? Thereafter, how that situation has changed. I will only take a minute to read the regulation.
Yes.
I will only take a minute to read the paragraph supporting my request for why, what is it that I have complained about which has required the court to pass. Court has not said that take someone out. Even if there is someone squatting in that property, if the situation has changed as on the date of filing of the suit, then perhaps a mandatory injunction may be required. But I'll just read for a moment 2-3 paragraphs. Plaintiffs have, after the registration of the injunction application,
broken into the suit property, caused dumping of some sand into the suit property on 18/7/2025. Plaintiffs have also brought third parties onto the suit property and were seen roaming freely in the suit property, despite the fact that a day prior to that, defendant had filed injunction application. Plaintiffs continued to hang their banner over the suit property and after entering the suit property on 18/7/2025. Plaintiff and their associates once again trespassed onto the suit property on 24/7/2025. Plaintiffs thereafter on 26/7 again entered into the suit property. I have supported all of this with photographs. The learned civil judge senior division has seen all of this. So therefore, an occasion arises for me to ask for a prayer of temporary mandatory injunction. Insofar as section 39 is concerned, the prevention of breach of obligation. The obligation is on them not to come into my property, especially when registered title deeds are there, possession is admitted on the date of filing of the suit. So therefore, the obligation is on them. And the breach of that obligation is by hanging up banners on my suit property. There are, and your ladyship will see holistically the chain of events that has happened. There are circumstances in which the defendant number 2 is afraid to approach the suit property in this situation. There are specific allegations which have been, and your ladyship will see all of my what has actually happened and see the chronology. There's a lot of forum shopping that has been done, and there is a lot of things which have happened under the nose of the court, both the learned civil judge senior division and this court. Now, one judgment which has been cited by, I'll not go into all of the other things. One judgment which has been cited by, there is a judgment Metpalli versus Metapalli Muthaiya. Registered will carries a presumption of genuineness. We may note that that was an uncontested. There, the defendant had noted and admitted that yes, these are my signatures on the will. There was no contest. This is a contested will, wherein a probate title suit is going on. Insofar as the order of the learned civil judge senior division is concerned, the judgment, which is of 6th of November 2025, there is a clear injunction which was granted. As on the date that the injunction is granted, whether right or wrong, that may be challenged in appeal, they should have kept their hands off the suit. That is the order which was passed. That order extended up till, and in between there is a, I showed your ladyship on the last occasion, on 8th of November, some letter has been filed with the Bharaloko police station that they have entered into the suit, something to that effect. So therefore, as on 8th of November also, they have said that I am in possession. Let's keep that aside for a moment. As on 26/11/2025, when this appeal was first heard, that order continues to stay in effect on 26/11/2025. On that date, I have shown photos, good or bad, whatever. Keeping the photos aside, the 6/11/2025 judgment is in force as on that date, and they cannot argue that they were happily and merrily in possession of the suit property in violation of that. This is a clear admission that they were in violation of that. But be that as it may, the situation on the ground as is reflected in the photos and videos that I have filed, your ladyship will also see, I have filed a pen drive to that effect. I was in possession of the property and my photos are there. In fact, defendant number 2 herself is there. The newspaper is held up. It's incontrovertible evidence. And your ladyship will see the preponderance of probabilities in such a situation, where I have no reason whatsoever to be in possession of the property, show all of my videos, show my persons coming in and out of the property, and then thereafter come and file this application alleging contempt because something has happened. And to that effect, I have already shown your ladyship that there is an FIR which has also been registered. So, ladyship will weigh the evidence, and none of which has come from the opposite side. Insofar as the photos and videos are concerned, some hyper-technical objections have been raised as to their authenticity. Leadership may take it from me. I can produce all of these devices and submit it before the court to be examined by any expert as to their authenticity. These photos, videos may be sent for forensic examination. Leadership may take my statement. But be that as it may, if your leadership directs in leadership's judgment, I let your leadership's judgment be subject to the forensic examination, these videos and photos, because I know that these are genuine. Insofar as the certificate is concerned, leadership will recall that earlier it was section 65B. 65B did not contain this part B of an expert. I cannot dispute the document. Yes, there is no expert available because leadership will see the practical difficulty. It requires some hash values to be provided of the files, which we were not able to. So to the extent that I have been able to provide a certificate, I have provided. I have given details of the electronics through which this evidence has been taken. And if I have not filed such a certificate, it is a curable defect. And leadership also knows that forms attached to a statute should not, in such a situation, be taken so strictly. If your leadership still feels that this is forged or fabricated, or I have filed close to 100 photographs and nearly 20 videos through various devices. It is not a case where I have, filed one photograph. There is a volume and body of evidence which I have shown in respect of the incident which occurred on 9th of January. Now, there is some allegations have been made that I have suppressed the filing of a contempt petition. It was not on the same day. I'll just clarify the chronology. On 26th of November, the status quo order was passed. It was also mentioned that photos are taken on record. Those photos that show me. On 9th of January, just before the Bihu holidays, this incident happened. And leadership may see the description of the incident and the videos. Because this court was not functioning at that point in time, we had approached the learned magistrate for registration. First, we had approached the Baralamuk police station. They refused to even take our. Then we approached the commissioner. He also refused to take action. Then we were forced to go to the magistrate before in section 156, the new provision. Finally, the magistrate held that yes, there some offense has happened, and to that effect, the FIR was written. So all of this has happened prior to 19th of January. On 19th of January, I filed 2 applications. One, which your ladyship is hearing, and I also filed a contempt petition. On 20th, the matter is heard. That contempt petition, for good, bad, or worse, that was not listed. What was listed in the urgency of the situation, we argued. Finally, this contempt petition came up by chance before another coordinate bench of this. Now, if there is a contempt of an order of the High Court, then I will file a contempt petition. I will not sit quietly and let him do whatever he does, including violation of status quo orders of the court. So, to that effect, I have exercised my rights. Only notice has been issued in the contempt petition. And I have made many other prayers in the present application. It is not only under Order 39 Rule 2A. This is a peculiar situation where a status quo order, which really does not clarify much, and leadership will have to infer from the chronology what has happened. I'll
No,
close
it's
my
okay.
argument.
Just
So there are other prayers also which I have solved. So your ladyship may exercise her inherent powers. These are exactly the circumstances where someone who has been thrown out, disturbed, her property has been disturbed, even after purchasing, after taking all of the necessary permissions, people have interfered with her possession, thrown her out, and it is only, I am remediless. I am remediless because I have gone to every forum and I have been thrown out of the property. And even with the High Court's order, again 10, 12 goons have come and disturbed my. So this is a perfect case where your ladyship will exercise her powers under Section 151 and pass necessary orders to do complete justice. Insofar as, I'll just end with one final line. Throughout these arguments, not once has the learned senior counsel said, apart from the fact that mandatory injunction and all of that, how the injunction order should not have been granted, and what right did they have over the property and to enter into the property repeatedly over several years. I don't have anything further to say apart from the fact that my arguments, I'll just pass on a copy. I've noted down all of my arguments, and for the convenience of your ladyship, all the arguments along with page references to various documents have been contained in this note. I have also prepared, just in the interest of time, which one is the court's copy? Anyone. These are the judgments which were cited by the senior counsel before also and today. I have prepared a note as to how these judgments do not apply in this situation. I'm deeply grateful to your leadership for a very, very patient hearing.
Lordship, there is an interim order, that there is an interim order that was operating.
It's operating. We'll pass the order in that manner. 2001.
2001.
Passing the order of 2001 repeatedly.
Milady, it is actually 2611, which was violated.
Now we are on
Your
2001.
Yes, your ladyship.
Otherwise, it was 20, that is the month of November, 2611, but now we are on 2001.
And your ladyship had mentioned in the 20th January order, 2611.
Yes, it has been mentioned.
Otherwise, the 2611 order is the continuation. It merges with
it
the
there are lots of things as
that
by
is
the other
their
side.
submission, Lord. It's their contentions. It has to be substantiated.
And what is the stage of the main suit there in this
You would
case?
recall that there were two applications which were heard together. One has culminated into this appeal.
Yes.
Second was the amendment application where they sought to change it to say that I have come into possession.
No,
that was rejected.
Now it is
not
for,
doing anything
no, it is,
adversarial.
No, I can understand that petition was
That was rejected. That was rejected. Thereafter, an amended plaint was filed on 19th of December, where again they say that I am.
No, that is
no. I'm just asking where
Lordship is.
the other case.
Now it has been listed on 18th of March.
For additional
for filing of additional written statement.
Oh,
I have to file.
Because we have filed the amended plaint. Now it is for additional written.
Okay. So you're going back today or you're staying today?
Oh, Milady, I've come so many times. I've stayed many days now, so I'll be going back.
enjoy Northeast,
Yes.
Guwahati, everywhere.
Milady, I've come several times, almost 50 times I've come to Guwahati.
Oh, acha, acha. Okay.
I have